Good evening. Happy Friday, August 22nd, 2025. Welcome, all of you. I hope you had a wonderful week and that the culmination of your summer has been pleasant, smooth, uneventful, where that is a desired outcome, and that it is cooling down wherever you are because it has been hot here, which finally started to cool down. So, how y'all doing? Where are you tuning in from? We've got a lot to cover today. So, we've got back in court a case that I was not previously familiar with. Really not. The case of Donna Adelson. So it was very interesting to get on board and start listening to a trial that is now, I think, the second or third trial, fourth trial of a single case. And to get an opportunity to witness a very effective prosecution and a stark contrast between what we see from jurisdiction to jurisdiction. So, what do we think? So far, those of you who watched the Adelson trial, let me know. Very curious. Katrina Bunny saying she called it the 9:07 start time. Kimberly Rudd is saying it was a fifth trial indeed. And I have to echo, I do love the judge. The judge is phenomenal. It has been very interesting not at all. Very interesting to watch that trial and the developments surrounding that trial. And what an interesting defendant, right? Oh my God, it's so weird. Oh, it's so gosh. But this week wasn't just a week of all smiles and joy. A viral judge, Judge Frank Caprio, passed away this week. For those of you who do not know or have never had an opportunity to observe Frank Caprio on the bench, phenomenal, just phenomenal. Pleasant, empathetic, very graceful when it comes to criminal defendants, and definitely one of those who's always seeing the brighter side of humanity and believing that people can always improve. But he passed away this week, which is quite indeed sad. A Suffolk University Law School grad. I feel like there was a lot in the Karen Reed trial that were all Suffolk grads as well. So definitely a loss indeed. So rest in peace, Judge Caprio. Okay. So how's your week? Let's see if we can't get caught up with the chat as Rob settles in, gets comfortable with where we are. Because there's all kinds of stuff. Oh, hey, Emily. How's it going? How's it going, Emily? Glad to see you here. I may have sent Emily a Dave Matthews thing this week. I don't know. It was various things. How you doing?
Hello.
Oh, look at this. A wild Canadian has appeared likewise.
I got distracted by firearm maintenance.
Those can be distracting. You'd rather be distracted by the firearms than distracted from the firearms.
I need to get a socket extension because there's a bolt, but it's way recessed. And they actually for some reason, they put in little flanges to prevent you from just futzing around with a wrench in there. So it's all right.
What are you messing with?
The stock is loose. So there's a bolt that holds the stock on.
Yeah.
I know. Inside the stock. So, yeah.
Firearms have a lot of specialty tools. you go figure, right? So.
Oh, hey, Emily, good to see you.
Yeah, sorry. She was lurking around. I think she was streaming all day. That Adelson trial. Did you get a chance to watch any of the Adelson trial today?
I watched all of the Adelson trial today. I think the defense strategy is real fun.
I was
actually kind of surprised. I'm like, that's a bold move, but it may well pay off.
It very much depends. Now, they started losing a lot of arguments that I think they needed to win in order for that strategy to pay off. Arguments about, I don't know, maybe comments that were made by Donna Adelson about the victim that they thought they were probably going to get excluded. I don't know why, but it was a decision and a really strong one. And the other thing that I thought was really wild was this criminal defendant is I don't know how so caveat. I did not watch the Charlie Adelson trial, none of it. So I know very, very little about this case other than the prosecution's opening statement, which if you are going to ever do a roadmap or a prosecution opening statement, I think this is going to be clipped and basically just shown to every trial advocacy student till the nth degree. Now, with one exception, I think every professor is going to look at them and say, so you see how they use technology? Don't try to do that. Just don't. It went really well for them, but it's not going to do that all the time.
Well, and one of the other things is I saw somebody like posting, oh, look, the prosecution's got this cool system and the defense has got like, poster boards. And I'm going, yeah, that's because the budget is for the prosecution, infinite money, right? They can just be like, oh, I need money. And they're like, how much money? It's like, the number hasn't actually been invented yet. Mathematicians have not named the number of dollars I need. And they'll just be like, okay, sure. But the defense, I assume I don't know if she's funding her own defense or if she is, or if she's on, some sort of assistance. But either way, it's going to be like, we have, and they'll just open up their wallet and like a moth will come out. And so they'll be asking like, do you accept payment in moths?
I don't know. I
and somebody says it's a free program. It might be a free program, but it takes time to do it. So
defense counsel seem to be pretty
Emily
capable.
Pointing out they've been able to use it for 3 trials. So they're getting great value. And that makes sense.
I realized that about halfway through the opening statement. I was going, it really sounds like they rehearsed this a lot. And then I thought in my head, I was going, no, they've just given the same opening with 1 or 2 variations in prior cases. Like, so technically speaking, yes, they've had dress rehearsals in front of live juries before. But I thought it was really good. I thought it was really good. Very good use of technology. Very effective because if you try to explain this case to other people, it becomes very convoluted very quickly.
It's very crazy.
There was also more than one moment during today's trial when I was looking at my misfits, and by my misfits I mean my lovable client list and opposing parties, and looking at all of the email exchanges and communications that they have buy-in between each other and all of the lovely things they refer to each other as and suggestive comments they make about how convenient certain things might be. I need reminder to Rob, circulate email to all clients saying, don't joke about these things ever.
Yeah, I had a client who joked extensively about wouldn't it be great if his ex got run over? And then she did. And you know how much he was investigated? So much.
Just all the investigation. Everything.
And like it turned out that it was a hit and run driver who had nothing to do with him. But they very much had some thoughts. They were like, and they were asking this other hit and run driver, like, so, do you want to flip on like anybody? And he's like, I don't know who you're talking about. So
he's like, are you a paid hitman driver? Like that, yeah.
And he's probably like, I would love to flip. Just please tell me the name of who I have to flip on, because they wouldn't tell him the name, like the other person, the name. And yeah,
it was something. It was something indeed. So today we had the opening statements in the Donna Adelson trial. They worked for 4 days to get a jury seated.
Yeah, that was actually pretty fast.
They did a good job. I mean, with how much media this case has gotten, not just this case, but the associated cases, the Charlie Adelson, the other cases that were involved. I mean, I'm surprised they were able to get a jury seated that quickly. Oh,
I also
and this
heard
judge,
that like one of the jurors or one of the prospective jurors was rejected because they were like the 911 dispatcher who took the original call.
whoa,
Yeah, right. And
what
I'm
are
like,
the odds?
I'm just like, ha, that's a whole moment, right?
Yep, that's something else. That's something else. But we'll see. Man, I had a good day in court today. I'm like still on a little bit of a buzz. It just we had a good week. We had a stressful week, but a good week. And I've got trial next week, so my brain is all over the place. It's going to be very interesting. Which, when your brain is all over the place and you're listening to a trial like this, it doesn't very much help because you need to kind of pay attention to what's happening.
I wouldn't know anything about that with your brain being all over the place.
No, not possible. I met with a new client this week. I met with a new client intake, and I have this sit down. It's an hour long, and just sit down and meet with them and talk to them about their case. We're going back and through this, and all of a sudden the client goes off on a tangent, and I go off on a tangent. And we both kind of realize about 5 minutes down this tangent that we are now talking about a completely unrelated thing. And he looks up and he says, "Sorry, I have ADHD." And I was like, "Oh, good. Me too." This is great.
Yeah, this is going to go great, isn't it?
So, it was like, my paralegal is going to be really involved here to keep us both focused. Yeah. Oh, look at that. These are Donna's second set of attorneys. She hired them $1 million, I think. $1 million, which doesn't go as far when you think about a criminal defense case, especially with this much of a crazy.
I have never had a budget like that for a case.
No, I mean, I understand that part, but a trial like this where you have multiple attorneys that you're funding.
Oh yeah, I mean, it's not an unreasonable amount. It's just, I just have some envy.
Yeah. Oh, this is a good question. Do I bill for my tangent minutes? No, because they always say that my meetings are an hour, but they're always last longer than that. I never bill the client for that extra.
I deduct I rarely bill per time, but when I do, I deduct for all right, I was on a tangent for a bit there, so we'll just write that down.
In what world? So this is a question for me. So the first set of attorneys were disqualified because they were Charlie's attorneys as well. In what world would the attorneys that were retained to represent Charlie not realize that that was an unwaivable conflict of interest?
I'm just going to say there's not a lot of smart decisions being made in this case in general. So
how do you go, okay, they're alleging a conspiracy. What if I represent two co-conspirators? There's no way that I'd be conflicted out of that scenario, right? Like a situation where one might want to point at the other one. And maybe that's how that would play. No, never in the ends of time has there ever been a co-conspirator that's like, I'm going to blame the other person. It said he waived the conflict. I don't know that that's a waivable conflict. I don't think it's a waivable conflict. I think that's a big problem.
I mean, let's say you have both sides sign off and they say, you know what, we are, neither of us is going to point the finger at the other. If the prosecution wants the lawyers off the case, they could just come to one side and say, we'll cut Charlie loose if, like we'll cut one loose if the other takes the deal.
Or they do,
and then your conflict
which is,
or
they stagger the trials. Instead of doing the trials at the same time, you put one trial after the other and you run the whole trial and you make it basically impossible for them to not point the finger at the other person because you convicted one of them already. So I don't know. I wasn't privy to that, so that's new to me. I guess we'll just have to see as we get into it. We are going to cover the little bit of testimony by the medical investigator or the ME. And the pause that was taken by the court. I can imagine some interesting words said by the prosecutor up at sidebar and the judge, because what the hell was that?
This sidebar brought to you by the numbers 1, 7, and the letter F.
I mean, I was going, okay, like, why are we crying now? Like, what is happening? Why are there like massive emotions being expressed? Okay, that was something. Good on the judge, though. This judge, he might be my new favorite judge, like, of all the cases. Maybe not. I don't know yet, but I'm very much a fan of this judge. I will try to get back to Fulton County. Fulton County took a rather large L today. One of them was a self-own. The other one was just a failure of proof. I mean, I don't know that trial should have gone forward in Wolfenbarger, but we shall get there. Niklas is raided, and he self-identified the raid. He goes, "It's a me raid." Okay. All right. So let me do this. Let's get caught up, and then we'll get to the opening statements, because I do want to cover all the opening statements. Oh, it was also very funny, the time disparity between it. Like, the prosecution was like, here, we're going to lay out this methodical opening statement over the course of 40 minutes. It was wonderful presentation. And the defense is like, cool, I'm going to take like 5. I'm going to take like 5 and talk 100% time about the victim. And I
have to say, it's really, really rare that you see the defense being like, the victim was the most awesome person on the planet, and this is a great tragedy against the victim. I'm like, did somebody not let them know what side they're on this one? Like,
yeah, it was
I just feel like there's a bit of a memo miss there. But
wait, it's like she ran this by the other ones, right? Like, she told everyone that this was her strategy for the opening statement, right? We all know this is happening. You're just going, holy crap. Okay. You hold your beer, because this is going to get interesting.
I do have a beer, but first I've got a gin fizz.
Niklas makes the great point. I love this. When Judge Everett stands up, cracks his knuckles, and looks at you, you're going to have a bad day.
Mm-hmm.
This is the other thing that I think was a great demonstrable contrast between some of the cases that we've had the opportunity to observe. Watch what types of antics the lawyers get away with in this courtroom. And I'll give you a little bit of a hint. None. Like, nothing. None. Objections are concise. They are limited to 1 or 2 words. The ruling is concise. The instruction and the ruling is very concise. The lawyers don't go way outside the bounds. This judge has complete control over his courtroom, and there's no doubt about it. Flip side, Fulton County, objection followed by a 5-minute recitation of everything improper, followed by a 2.5-minute response, followed by a judge making 3 minutes of clarifying statements in response to that. And then you have the same improper question again. I think they should make judges watch other judges try cases, like, more than just observing here and there. So it was quite fascinating.
I think they probably don't do that because it makes the worst judges feel bad.
I just care less about the judges. We're not. Oh, do it right. Just do it right. People have asked me, one of the questions I always get all the time about the YouTube thing, and how could I possibly talk about trial, and doesn't it get boring, or isn't it just a lot after a full day? It's like, I love watching these trials, because you get to relive and learn trial tactics and strategies, and you get to see trial after trial after trial with attorneys that are damn good or not, and then you learn examples of what not to do,
or at least partially good.
I mean, or you get some that are you're just going, what's going to happen with this dumpster fire?
I want to teach a course which would be like advocacy through watching famous trials. and just, go over things like, okay, let's watch this opening statement. Tell me, do you think this is a good opening statement? But also things like, all right, let's watch this opening statement that is a complete dumpster fire, and you could tell me how that went. Like Lolly's opening statement from trial 1 of Karen Reed. I'd just be like, so let's discuss, how that went, and if you think that was good.
Well, and then put it back to Brennan and be like, okay, so that went terrible. So there's no way they would tank the opening statement a second time, right?
The thing is they still at least did a little better than.
I mean, they did, but the over dramatic, all of the above. I mean, make the points. Don't get in an argument. Do a really good job. I mean, I liked this prosecution's opening, and I'm going to get to it pretty quick.
This prosecution's opening was really good.
It was very clean. It was remarkably clean. There was areas where it was like, are you getting close to argument? And then it's basically saying, no, the evidence. And then I'm going, okay, no, you're still there. You're in a good place. They did really well. So,
and you could see like the defense sitting there waiting to object. And the prosecution's like, nah, that's not what's going to happen today. I'm not giving you anything to object to.
Conversely, the defense's opening had quite a few objectionable moments if the prosecution had decided they wanted to. But if I'm watching,
think they wanted to, because at the end of the day, it was like, well, I don't know that the defense really moved much. And I thought the strategy of like, let's try to pretend that we're all on the same side here was like, you might want to pick a client who's a little less horrible for that.
And it was one of those things where if I'm sitting at the prosecution table and I have my notepad, I'm just writing in all capital letters, just W T F, like, and just showing like co-counsel and be like, is this really fucking happening right now? There's no way this is happening right now, right? Like, you're seeing the same thing. Okay, just wanted to make sure we understood what we were doing.
I had a client at one point who really got into like court drama stuff, and he's like, you need to write me more notes like in court. And I was like, I'll show you a note when I have something to show you. And this guy was like very serious. So I eventually like just did something. I think I did like Ziggy, the old thing with the person with the nose peeking over something.
Mm-hmm.
And then just wrote like, this is Ziggy. You wanted more notes, and slid that over. And he looked at it and went like, okay, I get it. And I was like, like, what do you want me to do here?
Yeah. Oh, I didn't. Yeah, the entire. We'll get. There were a lot of choices made, a whole lot of choices made, and I don't know that the proof will be in the pudding.
Which is not actually the right saying, because the saying is the proof of the pudding is in the eating.
Yeah.
The pudding is the subject of that saying.
We're just gonna have to see what happened. Melissa Webb, hope I can stay awake. I hope you can stay awake too. I hope I can stay awake as well. Linda Santiago, it's been a tough week.
Because if you can't stay awake, but the stream is still running, then I am obligated by law to cause trouble.
Today's 13-hour stream brought to you by Rob falling asleep. It's been a tough week. Yay, Friday Night Frenzy. Thanks for being here. Sorry, it's been a tough week. We'll try to turn it around. Lena H, ready for FNF from South Carolina. South Carolina has not gotten into too much trouble from what I've seen. Hopefully the storms have passed through from what I saw. Jessica B, thanks for becoming a member. Crazy Cat Queen is congratulating, and big congratulations to the lovely moderator, the Lady Draconis, who is
nice
and has become a PhD candidate. Way to go. Someone fixing the sword. There's a lot of emojis. You completely bypassed Nightbot with all the emojis in the super chat. But congratulations, Lady Drake. Nancy Druby, where the hell does the time go? Been a member for 20 months. I don't know. I still ask myself that all the time. Hokey Leah, thanks for becoming a member. Vez, hey Vez, member for 35 months, 1 month shy of 3 years. Glad to see you here. Elizabeth Love, happy Friday from Georgia. Happy Friday indeed. Nancy Druby, listening to you on my laptop, watching the football game on TV, no sound, and screaming at the damn Vikings. Well, now you can scream at a court, maybe, hopefully.
It's maybe a better thing to scream at.
Yeah, than football on TV. Don't get emotionally upset about football TV. Lady Fang 9633. Today's super chat's brought to you washed and stapled. Washed and stapled, indeed. And stacks of no. Well, I'm not going to say that. No, today's super chats should not be and cannot be in stacks of $1,000. No, I refuse. Annika, member for 35 months, coming in and saying hi. Look at that. My word, 35 months, another month shy of 3 years. Glad to see you, one of the OGs. Meg Webb's 94, finished the first week of school, ready to relax. First week is in the books. School and the children's have done all of the schooling and the education, and there was only there were no fights getting kids on the bus this week.
That's good.
Almost fights getting kids on the bus. You ever, there are kids where they are that borderline of, they have this outward appearance of being happy, but you know that if you say one thing, or if one thing goes awry, like if they go to put their shoe on and the lace were to break, or it's just like the wrong shoe, they are going to completely lose it, and any hope of getting them out the door is gone. We had that at least one night.
I'm pretty sure that's just like my entire childhood.
Oh, there was some tension. And I felt there were some parents that I saw walking down to the bus stop that I felt horrible for, because it was just children having full on meltdown. First day of kindergarten, like parents who literally pick their child up, like put the child on the bus and then turn to the body, like force the child to face away and be like, here, shove them up the stairs. Like, you go on the bus. No, you cannot come home. Yeah, it was interesting. Henhouse Bath can be on vacation mode, beach bound in 2 days. Congratulations. And again, Henhouse Bath Company, member for 32 months. Bran E. Nichols, looking forward to your input on this dumpster fire. Member for 35 months. Marmar, member for 27 months. Hello, love you both. Love all of you. Hope everything is going well. Hope we're all happy. Lady Drake coming in just to show off, member for 36 months, 3 years, 3 years this year or this month. Thanks for the congrats. You all have been my study partner on days I needed to complete assignments. I thank you, gents. We thank you, Lady Drake. Thanks for all you do. Moderating the chat, engaging with all the folks. So, what do you say? Shall we watch some of this Adelson opening statement? I think we should.
I think yes.
Before chat, I will remember to swoop. Just give me a second. Okay. Give me a second. I will get there. Let's try that. And we will swoop. There we go. Here we go. Cool Springs, 35 months. These folks are coming in with 35 months. 35 months. Wow, gosh, you all are amazing. Late but present. Margarita with the guys on a great Friday night. Whatever cocktail, whether that cocktail has alcohol or it's a mocktail, whatever you're fancy.
There's actually a pretty decent little mocktail bar here in Edmonton. I'm like, how does this place survive? But they do, and they're actually pretty good.
Hey, if it works, it works.
That's exactly it.
Don't break it. All right. So
they're really tiny, or I do like a meetup there, but they're really tiny.
Yeah. All right. Let me see. I want to boost the volume a little bit. I can't remember if the volume was good and adjusted for this one or not. I feel like it was. I don't know. We're going to do this. Hopefully it doesn't completely ruin everything. All right. Opening statements. Rock and roll. Donna Adelson, as some were already observing. So she's wearing the assistive headwear to help her with her hearing, because apparently she is hard of hearing. The glasses, the old, I mean, it's the sweater vest, or the sweater and the cardigan and the shirt. She was playing the part
as an aid to your memory. Is the state prepared to give its opening statement at this time? You may proceed.
Thank you, Terry, for being. Appreciate all of you, members and not.
Good morning, everybody. Again, I'm Sarah Catherine Dugan. Georgia Kappelman and I are representing the state of Florida in this case. And this is the defendant, Donna Adelson. We see her here at the defense table. And this is how she appeared back in 2014 when this crime occurred 11 years ago.
I like this because it's like, now she looks like an old grandma, but here's a picture of her looking younger and thus more capable of evil.
It's like, look at the stark contrast, like the fact that they immediately drew attention to it. Pretty wild.
Because
it's like, she wasn't always a sweet old woman. She used to look, I'm like, wow, that is that's a whole thing.
I mean, it's quite the contrast.
Was part of a conspiracy to hire a hitman to kill her former son-in-law, Dan Markel. This murder was set into motion because back in 2014, this defendant's family had a big problem. And the big problem was Dan Markel. And the solution to that problem was the defendant's son, Charlie Adelson. Charlie Adelson was the solution because he had a girlfriend with connections to the type of people who...
Hang on, for some reason, it's showing the whole thing. I don't want... Why? What's happening? I don't know what's going on. Give me 1 second.
You running into some trouble here? I just like how the prosecution is like, sometimes violence is the answer.
Why is it showing it that way? Oh my gosh, I'm an idiot. I'm so dumb. I was looking at this. Okay, so look. Oh God, this is going to be so embarrassing for me to admit this out loud. I was looking at this and wondering why it was that I could see the tab at the top of the screen. I'm looking at this going, why can I see the tab? Why does it look like why have I not shown the full video? Why is my browser tab showing versus anything else? And it's because I'm an idiot. It's not my screen. It's not my tab. It's their tab. Oh, I told you it's been a week. I told you it's been long. Look, it's okay. I get it. It's not my tab. It's their tab. So I was panicking, like, understood. I get it.
Were willing and capable of pointing a gun at a complete stranger and pulling the trigger. The victim in this case, Dan Markel, was known as Danny to his friends and family. He was a loving father to 2 little boys, and he was a highly respected law professor at Florida State University College of Law. Tragically, on July 18th of 2014, Dan Markel was shot in the head in broad daylight in the driveway of his home in the Benton Hills neighborhood here in Tallahassee. The last day of his life began like any other day of his that summer. He woke up, he took his 2 young sons to preschool, and then he went to the gym to work out. After finishing his workout, he returned home. He pulled into his driveway and he opened his garage. But little did he know that throughout his entire routine that morning, he was being followed by 2 hired hitmen who traveled all the way to Tallahassee from Miami for the sole purpose of taking his life. And like something out of a horror movie.
That's actually really good service.
He pulled into his driveway.
What?
Most hitmen won't put in that level of effort.
You mean going straight to the house, the driveway, the
Well,
door-to-door
coming
service?
coming a distance.
You mean they're driving all the way up
Yeah.
from Miami?
Like that
Well,
they
I
deliver.
also just how stupid it was to. I mean, so why hire the local hitman? I mean, the hitman that has to travel for you, I guess, because that's where you are. But this became kind of interesting.
Killers pulled in right behind him. Moments later, Dan Markel's neighbor heard a gunshot, and he looked out the window and saw a light-colored Toyota Prius back quickly out of Dan Markel's driveway and speed away. The neighbor thought that was very unusual, very suspicious, so he waited a second to see if Dan Markel also backed out of his driveway or came out of his house. And when he didn't see him, the neighbor got, a very funny feeling. And he went over to Dan Markel's open garage to see if there was anything wrong. And he found a gruesome scene. Dan Markel's car window, his driver's side window, was shattered. His glasses and his phone were on the ground next to his car. And Dan Markel was behind the wheel. He was unresponsive and moaning and terribly injured. The neighbor called 911 and law enforcement arrived to find Dan Markel with a gunshot wound to the head. He was taken to the hospital where he survived for about 14 hours before he was pronounced dead. Dan Markel was only 41 years old. And his little boys, who were deprived of their father after this murder, were just 3 and 4 years old. Bless you. Law enforcement began to investigate to try to figure out who did this, who shot Dan Markel. The scene there, the crime scene, left no trace of the killers. There was no fingerprint.
Yeah, who killed Roger Rabbit, or who framed Roger Rabbit? Great movie, by the way.
Or what's the other one? The one that was like big in like the 70s or something.
What, the cartoon one?
No, there was like Who Shot JR, I think it was.
Oh, I don't remember that one. Oh, and JR. There. I guess look at that. I didn't remember that one. Who shot JR? I didn't remember that. All right, I'm going to speed her up to about 1.25, and I will likely go to 1.5. I wanted you to get an understanding of her pace. For us, for entertainment purposes, that was a very dark thing to say. I take that back. Not entertainment purposes. For purposes of a recap and analysis, we don't have to hear it at regular pace the whole way through, because we need to make through pretty quickly. But I did want to give the chat an understanding of what her pace was, and it was slow. Methodical, it was deliberate, it was slow,
it's slow.
It was slow. She had the visual aid, which helps keep people focused. But it's also one of those where lawyers have their own pace and their own crutches and their own. So she could have sped it up a little bit, but is what it is. It was my only critique. So we're going to speed her up to, let's go 1.5, because we can hear everything she says at 1.5. She's methodical.
Prints, no DNA, no bullet casing, nothing was stolen. And so police began to suspect that this may be a professional killing. The little evidence that they do have sends them down 2 separate paths. One path is to track down that light-colored Prius that the neighbor saw fleeing from the scene. And the other is to identify who was inside that Prius. And the other path relates to motive. Who in Dan Markel's life would hate him enough to hire a professional killer to kill him? And after years of tireless investigation, both of these paths led directly to this defendant. So first, let's talk about the path involving motive. We'll go down both paths this morning. Police investigated Dan Markel's personal life to try to figure out a motive in this case, to see who might want him dead. And they learned that Dan Markel was entangled in a very nasty divorce with his ex-wife, who is the defendant's daughter. And his ex-wife is named Wendy Adelson. A review of the divorce case file reveals that Wendy Adelson had asked the court to allow her to relocate to Miami, where she was from and where her parents lived, with her children and Dan Markel's children, in order to be closer to her mother, Donna Adelson, to her father, whose name is Harvey Adelson, and to her brother, whose name is Charlie Adelson. The victim, Dan Markel, which y'all can imagine, is adamantly opposed to this, to his children being relocated to Miami. He works here in Tallahassee. He's a law professor here in Tallahassee. This is where he lives. This is where his kids have been raised. He wants his children here with him. A review by law enforcement of Wendy Adelson's emails made it clear that her mother, the defendant, hated Dan Markel and was the relentless driving force behind Wendy's relocation efforts to South Florida. And being a caring and involved parent is great, but the defendant's participation in her children's lives went beyond mere involvement or even meddling. She was extremely controlling. She had very strong opinions about all the decisions in Wendy Adelson's life, whether it be about her career, her relationships, or even purchasing a home. And if Wendy Adelson would not do as the defendant wanted her to do, the defendant often then enlisted Charlie Adelson, her son, Wendy's brother, to solve the problem by getting him to kind of go to Wendy and persuade Wendy until Wendy ultimately agreed to do what the defendant wanted her to do.
Side note, exceedingly common in divorce cases and family law cases for certain family members to be remarkably involved or demand significant involvement in decisions made about trial, in decisions made about the kids. This part kind of frustrated me a little bit. And when they get into how much of the family stuff, because a lot of this stuff is, I get, there's a lot where context gets lost.
And while the defendant had always been controlling of her children's lives, the emails uncovered by law enforcement showed that this defendant was desperate to find a way for Wendy and Dan Markel's children, her grandchildren, to be able to relocate to Miami. The defendant told Wendy that she deserved more than just a life teaching in Tallahassee without her family, and that Dan Markel was essentially holding her hostage in Tallahassee because of his job.
What an effective use of the technology. Oh, yeah. Outside the divorcing spouses. Oh, yeah. Lots and lots and lots of family members have very, very strong opinions.
You get it in criminal cases, especially domestic criminal cases too, where it's like, why is this guy's mom calling me?
Mm-hmm. Yeah.
And I get that you love your kid, but you don't actually get to have an opinion here. Sorry.
Yeah.
During the divorce and custody battle, the defendant's email showed that she was heavily involved in Wendy's court case, even going so far as to draft and edit the documents that Wendy and her attorney were filing in court, and emailing Wendy instructions for her attorney.
Oh, that's never happened to me before, ever. When a client, I get a redlined document back and it shows who edited it, where it's it's all interlineated with the red lines and the track changes shows who's leaving the comments. The number of times that I've seen the alleged paramour leaving comments, it's more than one, where I have a case that's entirely founded on allegations of adultery against my client. And all of a sudden I'm getting documents back to me where the edits are coming from a device that has a name that, you know what? Can we teach you how to remove that metadata before you send that kind of stuff?
Arguments her attorney should make and what her attorney should do. The defendant would guilt trip Wendy Adelson about how much time she and her husband, Harvey Adelson, were having to spend away from their dental practice to visit Wendy and the grandkids in Tallahassee, and complain about how the family was losing income, losing patients because of their constant absences from the practice. And the defendant instructed Wendy Adelson that relocation to Miami was the most important priority in this divorce, and if it had to be her non-negotiable in the divorce. In June of 2013, the judge in the divorce case ended up ruling in Dan Markel's favor. And not only did the judge deny Wendy's relocation motion, but the judge dismissed it in a way that prevented Wendy Adelson from requesting the relocation again.
Which isn't really possible. I think that might be a misunderstanding of law right there. You can seek a,
I mean, I suspect that just means that he dismissed with prejudice that thing, but
that one.
You can have changes of circumstance. You can have all sorts of things.
Yep, material change of circumstance might warrant the relocation, but I guess with that one, yeah. So I didn't really understand that. That was overplaying the hand, but
so Wendy would not be permitted to move to Miami to be close to the defendant and her husband with the children at that time or ever, unless of course something happened to Dan Markell. After the judge denied the relocation motion, after that was denied, the defendant told Wendy Adelson in emails that Dan Markell has not beaten the Adelson family yet. She let Wendy know that the Adelson family is a team and they are trying to win. Donna Adelson suggested in her emails several bribes to get Dan Markell to agree to relocation, like plane tickets, paying for her grandson's education, and the defendant even suggested offering Dan Markell a $1 million bribe to allow the relocation, to let Wendy move to Miami with the boys. And if the bribes didn't work, the defendant also suggested several ways that Wendy could threaten or bully Dan Markell into submission. The defendant told Wendy to aggravate Dan Markell like he aggravates you. And the defendant set out a plan of action that the defendant told Wendy would make Dan Markell absolutely miserable. And she's detailing all of these in her emails. So for the plan of action.
I love how downplayed she is in reciting this evidence. She says it details a plan of action that shows how it's.
She's detailing all of these.
Let's show this. I imagine that says, fuck her. What will make him absolutely miserable? Like she's like saying, developed a plan of actions and says, let's make him very frustrated. And it's like,
now I'm just wondering, is it censored in the original or?
I don't know.
Because if they didn't, like, if it's not censored in the original, I would have just put it as, you know.
I would have let it roll. I would have put it in there with the whole thing. Yeah.
In her emails. So for the plan of action, the defendant knew that Dan Markell was devoutly Jewish. So she came up with the idea for Wendy to pose Dan Markell's sons for pictures in front of a Catholic church, and then post the pictures to social media, and even announce on social media she was getting the children baptized just to make it appear to Dan Markell that she was changing their religion. The defendant assured Wendy Adelson that this would all be an act to get Dan Markell to agree to let her move to Miami, but told Wendy Adelson that in order to pull off this stunt, she had to put on the acting performance of her life.
The defense lawyer looking at her like
it did not matter
that was
Wendy
an
had to dress her two little toddlers up in Nazi or SS uniforms, as long as she was able to get them to South Florida and show Dan Markell that he was not in control. The defendant repeatedly told Wendy Adelson that the rest of her life, meaning Wendy's life, as well as the defendant's life, Harvey Adelson's life, and Charlie Adelson's life, depended on Wendy Adelson and the boys being able to relocate to Miami.
Leo has opinions. Leo is very frustrated. I don't know if y'all can hear it or not, but yeah.
And the defendant said that she would never, never, never give up and never stop fighting for Wendy and the boys to be relocated to Miami. And she never did. The evidence in this case will show you that this defendant's closest confidant was her son, Charlie Adelson. She and Charlie Adelson talk multiple times a day, every day. And he was the person with whom she would constantly vent and complain to about Wendy's situation here in Tallahassee, having to live in Tallahassee with her sons. And the defendant would use very dramatic life and death terms to describe it. The defendant portrayed Dan Markell to Charlie Adelson as a crazy person who was impossible to deal with and was causing an extreme amount of stress to Donna Adelson and her husband, Harvey Adelson. And Charlie Adelson was also the person that Donna Adelson relied on to solve her problems. And her daughter and grandsons having to live 8 hours away in Tallahassee was a big, big problem for this defendant. And this defendant made it Charlie Adelson's problem to solve. And although the divorce between Wendy and Dan Markell was final a year before the murder, throughout that year, litigation is still ongoing, to say the least. Each side is continuing to routinely file violations of the custody agreement, violations of the settlement agreement, and that continued right up until Dan Markell's death in 2014.
This divorce case must have been really nasty. Like,
I mean, some divorce lawyer made a huge amount of money on all of this.
I imagine based on the litigation, it was more than one. I imagine there was probably lawyers fired, then lawyers hired, and this sounds like this one got really contentious. Oh, like rules to show cause all over the place, contempt proceedings all over the place, protracted litigation over the kids. I mean, just two. Wow. Okay. Yeah. And it's not uncommon. Like the sanction, this isn't uncommon. This is not uncommon. Like it happens all the time. The sanctions. I mean, I got sanctions against another party today in a different case, like on a motion. It happens all the time. It's just two divorced firms. That's not bad. They must have both viewed their respective lawyers as being effective.
Or they must have both viewed their respective wallets as being bottomless.
They were, yes. So there's a distinction I want to make here. Yes, they were technically speaking lawyers, but to say that someone is a lawyer doesn't necessarily give you a whole lot of information about them. There are trial attorneys, there's corporate counsel, there's people who write contracts, there's people who teach law, there's people who took their law degree and become real estate agents. Just to say they're a lawyer doesn't necessarily mean that they're litigious and fighting and argumentative all the time. But this seems to suggest to me that they really hated each other, which happens. I mean, it's something.
A few months before the murder in 2014, Dan Markel alleged that the defendant, Donna Adelson, was disparaging him to his children. He was very worried about her trying to alienate him from his children.
Yeah.
She was doing this by calling him stupid in front of the boys and telling the boys that Dan Markel was trying to take them away from her. Dan Markel asked the court to prevent this defendant from having unsupervised contact with her grandchildren. And this motion was still pending in court when Dan Markel was killed. And the murder of Dan Markel ensured that not having access to her grandchildren would never be a problem for this defendant. And what do you know? About 48 hours after Dan Markel was killed, after the shooting happened, Wendy Adelson and the little boys relocated to Miami, moved into the defendant's home with her, and the boys started school down the street. And just like that, their father was effectively erased from their lives, and the Adelson's big problem had been solved. You'll hear during this trial that the Adelson family is a very tight-knit family. The defendant, her son, Charlie Adelson, and her husband, Harvey Adelson, actually all work together at their family's dental practice. The defendant, Harvey Adelson and Charlie Adelson are dentists there, and the defendant managed their accounts at the office. She was the details person. And this defendant, though, she managed much more than just the office for the Adelson family. She was the matriarch, and a domineering one at that. She ran the office, the home, and the lives of the Adelson family members. After Dan Markel was killed, law enforcement interviewed Wendy Adelson. Wendy Adelson told police, and the police confirmed this, that she was at home having her TV fixed, at her home in Tallahassee, having her TV fixed at the time of Dan Markel's murder. And when police asked her, well, do you know anyone who would have a motive to kill Dan Markel? Wendy Adelson acknowledged that her family had a motive to want Dan Markel dead and said that her parents had more reason to dislike Dan Markel than anybody else. At one point in the interview, police allowed Wendy Adelson to make a phone call to her parents to let them know that Dan Markel had been shot. And after she got off the phone with her mother, the defendant, Wendy Adelson said to police, well, they acted surprised, so that's a relief.
I mean, that's, come on. Like, I do. This is one of those things where I understand, like, that
it's still funny, and I would still use it if I were in their shoes, because it's not. I don't think it's improper, but I do get your point about.
Really, of course, they're going to come back and say that. Like, come on, and the other statement of that, her family had plenty of reason to want him dead. I imagine
every divorced family has.
Yeah, I get it. When I tell you that there are clients that I'm sending emails to this coming week with pretty specific instructions like, hey, so I want you to check out this opening statement and I want you to look at these emails. This is a murder trial. So next time you decide you want to write emails, why don't you tone down the rhetoric a little bit? Like, just don't be stupid.
Yeah, keep in mind, everything you write down, the other side could probably find out.
At some point in time.
And when asked by law enforcement if anyone could have killed Dan Markell on her behalf, she also told the police about her brother, Charlie Adelson. Wendy admitted to police that her brother, Charlie Adelson, had joked that he looked into hiring a hitman to kill Dan Markell as a divorce present, but decided to buy her a TV.
Okay. The number, I don't know if I should say that out loud.
Rob does not provide that service.
No, I do not provide that service. Hypothetical divorce clients who make a joke at some point in time about how a hitman would be cheaper than the divorce they're in, it is surprisingly there's a percentage that is greater than 5% of cases that a joke will be made in that nature about the spouse. It is a reality of divorce. It is very much a reality of divorce. Now, here's the thing. Then turning the TV salesman into the code word is very, very stupid. But this is probably a good point. Sell it. I would not recommend.
What I'm just kind of astounded by?
What?
This is like the first hitman case where there's actually been a hitman. Because like 99% chance if you're hiring a hitman,
it's a fed.
It's a fed. And I'm like, wow, they actually found a hitman who wasn't like, wasn't just a fed. And I'm like,
that is a good point. But then again, I
think still doesn't work out.
I might still send this, even though this is I don't want to give them ideas because I want to tell them like, look, this person. No, I don't want to give them the idea because they're gonna watch how it was done. They'll be like, oh, I could do it better than that. I don't know if I want to do that. I'm just gonna stick with the whole don't do stupid things.
The thing is that you could totally handle this situation better than they did. Like, because they run into this problem of the hitman starts blackmailing them and all of this. And I'm like, there is a simple, easy solution. And you know what that is?
Oh, God. I'm
just
scared.
Move. Like, the whole thing was like, we need them to, like, bring the kids here. I'm like, or you could just move closer to where the kids are. And you would, like, not be going to jail for the rest of time. Why do people not have the ability to think of like very simple solutions to their problems?
You guys understand, we are not laughing at a murder. This is a trial. It's a trial. I'm not laughing at a murder.
We're laughing at the trial and the stupidity of murderers.
The stupidity of the murderer. And the fact the defendant got caught. I don't ever mistake any of that. It is a trial. So you can have that opinion, and that's fine if you're not comfortable being here. But I'm not laughing. I'm not joking about, Dan Markell and how he was as a father or anything else. I'm also just saying that these situations, while they might appear unique from some of the factual standpoints, I mean, they're one or two steps removed from actual cases that I will handle in the divorce context quite a bit. Like, it's pretty. Oh yeah, the washing the money and thinking it was laundering. Yeah. That's
instead because it was cheaper. And what do you know? The same TV that Charlie Adelson bought his sister as a divorce gift would be Wendy Adelson's alibi the morning of the murder. An alibi, the TV repair appointment that was set up by her parents, Harvey Adelson and Donna Adelson, the defendant. So this path of looking into Dan Markell's personal life to see who would have motive to kill him leads law enforcement to the Adelsons, including this defendant, a woman who vowed to never, 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 never give up on getting her daughter and grandsons to Miami, and her son, Charlie Adelson, who told his family that he'd looked into hiring a hitman to kill Dan Markell, as Wendy said, was just a joke. But if Charlie Adelson was just joking about hiring a hitman, that joke, that stopped being funny when Dan Markel was actually killed by a hitman. While the police are trying to investigate motive, they are simultaneously following that second path of the investigation by tracking down that light-colored Prius the neighbor saw fleeing from the scene. When law enforcement retraced Dan Markel's steps on the morning of his murder, they uncovered some very chilling surveillance video of that light-colored Prius fitting the description given by the neighbor, following Dan Markel into the Premier Gym parking lot and waiting for an hour while he was inside, and then following him home from Premier Gym back to Benton Hills. And these surveillance images, coupled with a massive amount of phone and SunPass records gathered in this case, help police track down the exact car used to commit this crime. But police still had to figure out, okay, we got the car, but who was in this car? And why did that person kill Dan Markel? So law enforcement did a painstaking review of digital evidence in this case. And when I say painstaking, finding this Prius and finding evidence in these phone records was not an easy task. And it took much longer than your average investigation of a shooting, as you'll hear. But law enforcement eventually found that needle in the haystack. They found a number that communicated with the cell tower that services Premier Gym at the exact time when the Prius was there. And it was a number with a Miami area code. And that number belonged to a man named Sigfredo Garcia. Law enforcement examined Garcia's call logs, and they saw that he was in frequent contact with another number that was present at Premier Gym that day. And that number belonged to a man named Luis Rivera, who is a longtime friend of Garcia, and he's also from Miami. They both are. Police then looked at Garcia and Rivera's phone records, which showed that their phones left Miami 2 days before the murder, so July 16th. They came to Tallahassee, and on the day of the murder, on the 18th, they followed Markel to Premier Gym. The phone data...
Like, really? Just, you took the phone with you to do the criming all the way from Miami to Tallahassee.
Hey, he likes that phone.
You didn't think that maybe just leaving the phone at home and a burner might be the more appropriate thing to do?
I mean,
rented a
killers
car in
never
your own
really
name.
do a whole lot of thinking, because the instant you start thinking about these things, you get to conclusions like,
Crime.
wouldn't it be easier to just not do the killing? Like,
Yeah.
isn't this just a bad idea all around?
Yeah.
You know, it's like,
Maybe.
why are criminals dumb? It's like, because in general, when you actually like plot it out, the smart thing is just not to do the crime.
They didn't plot it out very, very well. They really didn't.
shows that these men turned their phones off just minutes before the murder took place, and their phones then stayed off for about an hour or so after the murder until they were well southbound to Miami. I think around the Gainesville area, the phones turned back on. And then once they got back to Miami, a bank's ATM camera caught them in the light-colored Prius at a bank drive-thru and caught both of the men in the Prius.
Look at that lovely image. It clearly shows, like, couldn't be more clear. It's face for both of them in the car. It's almost like one is leaning forward with the express intention that the camera would catch the other one, right? Like, it's the clearest ATM photo to ever exist. Have you ever seen ATM photos?
Oh, they're often awful.
They're horrible. This one is like in HD. It's like, hey, oh, we can see both of you. Wonderful idea.
So police figured out the identity of the two men responsible for following and killing Dan Markel, but they continued to look for evidence to explain why these seemingly random men came all the way to Tallahassee to kill a man that they'd never met. What or who is the connection between the killers and the victim? The defendant in her emails obviously had demonstrated ample motive to want Dan Markel dead, but how do we get from these two random and hired killers to her? Well, those phone records that I talked about, they revealed that one of the shooter, Garcia's, most frequent contacts was a woman named Catherine Magbanwa. She goes by Katie. The shooter and Magbanwa have a long history of an on-again, off-again relationship, and they share two kids in common. This is Garcia and Magbanwa. And lo and behold, these two paths of the shooter's car and the motive, they converge when law enforcement sees that Catherine Magbanwa is also one of the most frequent contacts in the phone records of Charlie Adelson, the defendant's son, the same son that she had been nagging to death about his sister being stuck in Tallahassee. Law enforcement also learned that at the time of this murder, Catherine McBanois was dating Charlie Adelson. So Dan Markel was a problem the defendant needed to solve. The defendant's son, Charlie Adelson, was looking to hire a hitman to kill Dan Markel. Dan Markel is killed by a hitman. And who ended up being the hitman? The hitman that killed Dan Markel? Someone with a close relationship to Charlie Adelson's girlfriend, the father of her children. So you can see how both paths, followed by investigators, charted the way to this defendant. Not only by looking into the motive, led law enforcement to the defendant because of her hatred of Dan Markel and her son's apparent efforts to hire someone to kill him, but also looking into that car fleeing the scene led law enforcement to the defendant through her son's girlfriend at the time. So 2 investigations, 1 conclusion. Law enforcement also tried to follow the money in this case, and that was a third way that the evidence in this case pointed to the defendant. Law enforcement reviewed.
The way I appreciated this graphic and this visual, I cannot express. Like this made my life so much easier to track this case. And this was where I was like, thank you, prosecution, for putting together this visual. Because they went through a ton of names. And I'm like, it'd be great if I could visualize how these names all should stack up. Like, how am I supposed to look at this family, this dynamic, and these people?
No, Lally teaches us that the way you do this is you just rattle off name after name after name, and you don't explain like who they are or why we care about them. And
you just say they were there, right? They were there, right? They were there, right? Yeah. This was great though. This one was definitely the easiest way to process what we were just watching. People are saying, are we able to zoom in at all? Not really. I wish I could. I mean, I could probably find this exhibit somewhere. I imagine they'll probably show it, but I can't hold my mouse. So there's Donna Adelson. There's Harvey Adelson, so husband, wife. There's the daughter, Wendy. There's Dan Markel. So blue box, and then a little line there, just showing the marriage. Got Charlie Adelson, Katie, Mr. Garcia, and Mr. Rivera.
Bank records, employment records, DHS-MV records of all the suspects, and saw that in the months after the homicide, Garcia, Rivera, and McBanois all acquired some big ticket items. Rivera and Garcia both bought motorcycles and cars. McBanois got a breast augmentation surgery and later received a black Lexus sedan whose previous owner was Harvey Adelson.
I mean, why? Don't go out and spend the money like within a month. Like that. Have you never learned a crime? No, they haven't learned a crime. They're doing time because they didn't learn a crime.
I mean, to be fair, there aren't really crime schools.
There aren't. And
I feel like these people are not really overly troubled by the availability of schooling in any event.
I did think it was funny though that it did make me laugh, just to chuckle, but a little bit inside. Like the dudes got motorcycles, she got boobs. Okay.
To be fair, the dudes were probably less inclined to get paid in boobs.
Not their own augmentation. They probably would have gotten paid. I mean, they probably spent some of that money looking at boobs, but I don't know that it's augmenting their own.
I'm just saying, if they got an offer of like, hey, we could give you some surgery, give you a really great big, they'd be like, what else you got? You got
Take the motorcycle, please. I'll take the motorcycle.
I'll take whatever's behind door number 2.
If you didn't catch him, the motorcycle probably would have killed him. So it's just
McBanois' bank records were analyzed, and there was no check ever written or matching cash withdrawal for the car or the breast augmentation. Bank records also showed that McBanois' account had a huge spike in cash deposits around the time of the murder. She deposited more money in her account in the 5 weeks after the murder than in the entire year before the murder. And this was during a time when there was no record of her being employed anywhere. And also, about 2 months after the murder, this defendant added Catherine McBanois to the payroll at the Adelson family's dental practice, the one that she kept the accounts for, the defendant kept the accounts for. And the defendant started issuing her regular checks from their business account every 2 weeks, despite the fact that she did not work there at the time. McBanois didn't work there. Law enforcement noticed that each one of the 44 checks that were written to Catherine Magbanua every 2 weeks over the course of the next 2 years after the murder were signed by this defendant, Donna Adelson.
Can I just say how much I love opening statements for one reason?
Why?
You've got a person who's got to sit there and hear about. I love opening statements on like carefully planned murder allegations, because it's like, and here's all the things you did wrong.
Here's all the stupid stuff you did.
It's
This was the first time when we went through. So we go through all of it. Like we go through all this stuff in the back and forth with how Donna Adelson was very involved in the divorce, and you got to get the kids down here. And I'm going, this is kind of thin. This is kind of thin, kind of thin, kind of thin. Where's the connection? Where's the connection? And then it's here. It's like they hired her.
Yeah.
And she started cutting her checks.
The thing is, as a defense lawyer, I can just be like, hey, there is ways to explain that away.
But then when they go
it's not going to be easy, but
it's not. But when they go and actually subpoena the records and they go to the dental practice and they're like, who is this person receiving the money? And the lady at the front desk is like, I don't know this person. Who is this person?
That's the point where you go like, we were getting ripped off. Like we were getting defrauded.
Mm-hmm. And then someone else has to come out and explain like, oh no, they're on the payroll, but we don't know what they're doing. We have no clue. That's handled by this one person, only one person in the company that writes the checks for her. Only one person knows why she's here and why she's hired. Just going, well, this is where I start to look at Donna Adelson like, well, this is the first, for me, this was the first stepping stone towards a guilty verdict for her.
Yeah. And I think that's very fair. Like to say, this here's a bad fact.
Yeah. This was a bad one.
The money was talking, but what about the suspects? Law enforcement wanted to know what they were saying. In examining the phone records in this case, law enforcement noticed a distinct pattern of communication surrounding important events or dates in this case. The phone calls always went from this defendant to her son, Charlie Adelson, and then from her son, Charlie Adelson, to his girlfriend, Catherine Magbanua, and then from his girlfriend, Catherine Magbanua.
And this is also a bad fact.
And then back the other way,
yeah,
like train cars. They only seem to touch the car directly in front and directly behind them. The defendant never calls her son's girlfriend, Catherine Magbanua, or the shooter, or vice versa. Charlie Adelson never calls the shooter, or vice versa. So, if this is a murder for hire conspiracy, as law enforcement suspects, could it be that the defendant and Charlie Adelson are wisely insulating themselves from the actual shooters by having Magbanua act as the middleman? Law enforcement decided to launch an undercover operation designed to clarify who are the members of this conspiracy and how information was traveling within the conspiracy.
And this operation was expensive. Like when she detailed this operation, I was like, holy crap, this is
what I mean when I say that the budget for the prosecution is just like, we're going to the budget for the prosecution is like one Scrooge McDuck tower, right? That's, it's like fill a silo full of money. And that's what we're doing.
This investigation was insanely impressive as she was detailing it. And I'm going to wait until they start to testify to it, because I'm imagining that you're going to start to see the defense taking some attack on the investigators. And you've already seen a little bit, but when she's detailing the investigation, this thing was comprehensive AF. I mean, yeah, some stupid mistakes by the individual defendants and the perpetrators, but holy crap, was this involved. I mean, they did everything.
Police applied for and received court authorization to listen in real time to the phone calls of Charlie Adelson and Catherine Magbanua, the people in the middle of this train car. And this is what's known as a wiretap. By this point, though, it was April of 2016. It took about 2 years to do this investigation to find out who was in the car and to get this wiretap going. So at this point, it's been 2 years, almost 2 years since the murder. And at this point, in April of 2016, Charlie Adelson and Magbanua are no longer dating. They've been broken up for over a year. Catherine Magbanua at this point is actually back together with Garcia. We heard they're on again, off again, and have these kids together. Charlie Adelson has moved on he's had many other girlfriends at that point since Magbanua. And Charlie Adelson and Mac Vanois, though, they are still friends. They remain close friends since their breakup, and they're still in regular communication by April of 2016, even though they're not together anymore. Rivera, the second hitman in that Prius, was in prison by this point, doing time on an unrelated charge. And the defendant is happily taking care of her grandkids all day, every day. So all the members of this conspiracy have.
When you heard that one of the hitmen was in jail for another crime, I was like, yep, that tracks. Like that.
Yeah.
Presumably.
And often that's when they come
believing
and
they've
say,
gotten away with
hey, you know, jail kind of sucks, but I do have a whole pile of information I can trade.
Yeah. This is a great comment. Their leaf blower had a GPS. Oh, yeah. This investigation was so much just, yeah. Yes. Ian is a criminal defense attorney. I am still an active divorce attorney. We both are trial attorneys that practice in court still. So, yeah, we are both still practicing lawyers.
murder. So what reason would they have to be discussing the murder at that point if police are listening in? They wouldn't. So police needed to stage an event that would generate some conversation, some activity between the members of the conspiracy so they could see who the members of the conspiracy were. Their plan was to send an undercover agent posing as someone on behalf of Luis Rivera. He was the hitman who was incarcerated by April 2016, to walk up to the defendant, Donna Adelson, on the street. There's a fly right in front of me. It won't leave me alone. To walk.
Yes, the fly was my favorite part. And the fact that she called it out, I loved it. She immediately was like, there's a fly. So if I'm going to start swatting around the air, just don't look at me.
She's like, it's not because I'm on drugs. I'm just, you know.
Well, and the fly is an equal opportunity pest because defense counsel gets up later and the fly starts bugging her. And she's like, oh, yeah, that fly really is annoying. Yeah. Donna Adelson's wearing headphones because they are auditory assisting headphones. So she apparently has hard of hearing. So that's why she's wearing the headphones.
I mean, isn't she like 802 at this point?
Well, she's trying to look that way. She really is. So I'm looking at this.
I mean, I'm not trying to be insulting other than just like, it just makes sense.
So I'm looking at this. He might have taught civil law at Florida State. However, I'm looking at this. He was Canadian-born attorney and a law professor. He wrote various works on retribution in criminal law and sentencing with a focus on the role of punishment in the criminal justice system. He earned a JD from Harvard in 2001, worked as a clerk for a federal judge, associate at a law firm, then joined the faculty at Florida State University. So good for him. I mean, it actually looks like he actually did practice. Let's see. The title of he co-authored a book. Oh, no. That is actually remarkably sad. He co-authored a book titled Privilege or Punish: Criminal Justice and the Challenge of Family Ties.
Ooh.
Like I said, remarkably sad.
That's some irony.
Yeah. But it looks like he did consult in trial practice too. I mean, it's pretty interesting. I bet he was. Huh. That's sad. Okay. That was what I was trying to get caught up on. Some of the questions that I was seeing there. Byron Butterfield, at least the money seems to have been usefully spent. What are the costs compared to Karen Reed? These costs, actually, I take that back. I don't know. Because the Karen Reed cost, that second trial, the experts they hired and the money they paid to counsel was outside counsel. So those costs are paid. Those are remarkably excessive. These are not special counsel. And to my knowledge, they don't have any outside hired experts. The experts are all police and law enforcement. I don't know that there would be a way of comparing the relative cost between the two cases. I'm not sure. Ran E. Nichols as an office manager at a dental practice. I don't understand how the checks to Katie were in sequential order. Probably because they had a set of checks that were in the office physically handwritten checks that were just had a progressive number. So let's say you have a checkbook or your QuickBooks checks, the checks that you write electronically, all begin with 10, and then you have like 10001. Then you would have a set of book checks in the office that might begin with 30, 30001 that are just handwritten checks. So that might be why they're progressive. It's out of the petty cash or something like that.
Or it might be that she gave her a stack of like post-dated checks.
Oh, that's also true. She could have given to her one time and said deposit these intermittently as they become available. Crazy Cat Queen. Wendy was also a FSU professor, medical legal partnership law. It is going to be insane. That is.
Walk up to Donna Adelson on the street and try to blackmail her for money. Law enforcement refers to this as a bump. So this undercover agent posing as a blackmailer, and this is an actual picture from the surveillance cameras, that this is the undercover agent passing a piece of paper to Donna Adelson back in 2016. This undercover agent is posing as a blackmailer. He hands the defendant a piece of paper, and on the piece of paper is a news article about Dan Markel's murder. And written on the piece of paper is a phone number and the amount of $5,000. He tells the defendant that he knows the Adelsons are taking care of Katie, and he's basically there to blackmail to get more money out of them or out of her on Rivera's behalf to even things out because he knows they're taking care of Katie. He never says Charlie Adelson's name or anything about Charlie Adelson to Donna Adelson. The defendant then puts the piece of paper in her purse and walks away without ever looking at the piece of paper because she knew exactly what it was about. Then law enforcement listens in to see what will happen next. Will the defendant go straight to the police to report the blackmail, or will she do something else entirely? And as suspected, based on
Nobody
the
goes
previously
straight
observed
to the
communication
police. Come
pattern, the first person that this defendant calls is Charlie Adelson, despite the fact that the blackmailer never mentioned Charlie Adelson to her. On that first call, you would think the first thing that Donna Adelson would say to Charlie Adelson is, "Oh my God, so crazy. Some man just came up to me, handed me an article about Danny's murder, and he's demanding money from us." But she never says any of that. In fact, the defendant never says Dan Markel's name at all. Instead, she tells Charlie Adelson that she needs to talk to him in person about some paperwork that was just delivered to her.
Yeah.
She said that
this is starting to be set of evidence number 2 for me.
Yeah.
That starts to really start lining up. Like the way that she handles this was such an effective law enforcement operation. So effective. And the fact that they just she had to know that the phones were being monitored, and it is clear that she kind of maybe thought it, but didn't really.
The thing is that when people think they're being tapped, they're never careful enough. Because what they start doing is they're like, "Will you bring the birthday cake to the,
well, it's
party?"
It's this one.
And
because what would you expect? Let's say, what would your first phone call be? Some random person approaches you on the street and gives you a newspaper article, and like, "I know this person. Give me $5,000 or else." I'm going to basically say some unhinged person just gave me this piece of paper and started threatening me. Like, I don't know what the fuck's going on. I would immediately go into this long-winded, like, what the hell is happening? But she's very, very, very clear, very brief. This is sus AF.
I mean, the thing to have done would have been something along the lines of, Chuck. Can you imagine like how it changes things if she just chucked it out, like looked at it and went like garbage?
Oh, this case is very, very different. If she doesn't write the checks, if this person isn't hired, and if there is zero communication after this bump, this case looks very different.
If they actually wanted to do like the money through the dental thing, there's ways. Like they could have made that. I'm not going to go into too much detail, but
they had stacks of cash.
Or hell, just give her a bag of gold teeth.
They had the ability to do this. Now, this is wild.
the two of us.
I have never been paid in teeth, by the way.
And that he should know what she's talking about. The defendant and Charlie Adelson continue talking, and she says that he should bring cash to their meeting. And she says, the TV is probably about 5. The defendant tells Charlie Adelson that the man who approached her mentioned an ex-girlfriend. The defendant never says which ex-girlfriend of Charlie Adelson. She never says Magdano's name to Charlie Adelson in that phone call. She only says that the blackmailer mentioned an ex-girlfriend. Charlie Adelson never asked his mom, my ex-girlfriend? Which ex-girlfriend? He's had a lot. He never asked that. Because as the evidence will show, he didn't need to. He knew the TV is probably 5 meant that she was being blackmailed about Danny's murder, where the TV was the alibi. And he knew that the ex-girlfriend in question was the only ex-girlfriend that he had solicited to find a hitman for him, Catherine Magdanois. And we know that because after this call with his mother, the defendant, Charlie Adelson, calls Catherine Magdanois. He does not call his most recent ex-girlfriend or even the one before that. He calls Catherine Magdanois. And his call to Catherine Magdanois is the only call he makes to any ex-girlfriend after getting the information from his mother that the blackmailer mentioned an ex-girlfriend.
Whoops. Just fucking crazy. Just law enforcement must have been sitting there going like, there's no way they're going to do this, right? Oh my God, they're actually talking. Like, this is real. He's really calling her, isn't he? Oh, I wouldn't make a phone call. That phone is now dead to me. Nope. That phone has now no longer exists, is recoverable. Nope.
I mean, I don't get it because I'm just like, I look at this and I'm like, all right, so I got to be careful because like the Law Society doesn't want you giving away too much. But like, they're like, we think this phone is tapped. So people start going like, oh yeah, we're going to like go to the place and do the thing. And what they should be doing is just not talking on that phone at all. Right? Like if you think the phone is tapped, stay off the phone.
Mm-hmm. Yeah. The sociopaths, the ones that are the scariest are the ones that continue in their daily communications as if nothing transpired. Like no uptick in communications, no change in communications, no nothing. Because even destroying the phone would be a red flag. Now it would accomplish,
especially if you say left it at like a military base.
Oh yeah, like in a dumpster that state law enforcement hypothetically couldn't get a search warrant to search. It's just one way of making it impossible to retrieve.
I mean, that would also look super sus, right?
I mean, it probably would. I would find that to be, but here's the thing. But you have to, before you drop the phone off, you have to take a limited extraction of your own messages and print them out. Just print them out into a stack of papers, and then make sure you have that with you before you go and destroy the actual device, or allow it to be destroyed in a place where you can't get it. Say what you will about the Brian Higgins cell phone or the Brian Albert cell phones. It was a smarter way of handling the damn phones.
I mean, it was.
But to the point the chat was making, to the point that made before, destroying the phones don't help you. It doesn't help you. Because that immediately also looks suspicious. So, like I said, the sociopath is the one who can actually have that happen to them and then continue going about their day as if nothing transpired, or the truly innocent person, which, generally speaking, by the time law enforcement gets to this level of investigation and is willing to spend this amount of money, this amount of effort, I mean, they've got something.
And he hadn't dated her for about 1.5 years at that point. And although they threatened to do it very often, neither Charlie Adelson nor the defendant ever reported this attempted blackmail. to the police. You all will hear the calls between the conspirators, and as you listen to these, you'll notice that they're being very cautious about what they say. It's apparent that they're being very careful about the words they use because they are all...
Oh, says the prosecutor. That's not fair. You should absolutely discuss every element of your criminal conspiracy on the tapped line in detail. Same goes for the jail phones. That's not fair, Elf Wiggins. You know better than that. You don't tell people how to get caught, says the prosecutor.
The prosecutor telling people how to get caught is in fact on brand.
That very much is the point. Yes.
Immediately suspicious that law enforcement could be behind the bump. Law enforcement could be the person who came up to them on the street and gave her the paperwork. And law enforcement could also be listening to their conversations. After Charlie Adelson's first call to Catherine McVanois, Charlie Adelson then meets up in person with his mother, the defendant. And in person, she gives him the paperwork that this blackmailer gave to her and makes it Charlie Adelson's newest problem to solve. And naturally, what does Charlie Adelson do? He goes to the next train car, Catherine McVanois. Charlie Adelson and Catherine McVanois meet in person at a restaurant called Dolce Vita in Miami.
Good
And while
analogy,
they sit
train
at their
car, by the
table
way.
in this busy, noisy restaurant, an undercover FBI agent is sitting at a table nearby with a camera hidden in a bag, recording the conversation. So this is
So
an
much
image
money.
from that
much
video
money.
recording the conversation. And in the recording, we hear Charlie Adelson discussing whether the man who walked up to his mother could be an undercover police officer, or he could be someone trying to
The
legitimately blackmail
undercovers
him.
are sitting there
And
snickering.
if it's a blackmailer,
the entire time.
Just how did they keep a straight face? He's sitting there with a camera in a bag. I don't know if it's male or female, but the FBI agent's just sitting there going, oh shit, they're really going to do this, aren't they? They're really going to do this. Oh my gosh. And people that are saying motion for 1.5, we're on 1.5. So we're sped up.
is it somebody who just saw a way
She's
to
got
make
a
quick
very
buck?
slow cadence.
Or is it
Yeah.
another situation entirely, which would be much worse for the Adelsons? Is it actually someone with inside information about Donna Adelson's role in the murder of Dan Markell? And that person could tell police what they know. Charlie Adelson reassures Catherine McVanois, that if it is the police, that is a good thing. Charlie Adelson thinks that, hey, if it's the police, that means the police don't have enough evidence to charge anybody. You know, they're just fishing for information. And in fact, Charlie Adelson tells her, hey, if they had any evidence, we would have already gone to the airport. It's important to note that at the time of this conversation at Dolce Vita, no arrests had been made.
This is the first time I've actually paid attention and noticing that she is swatting around that fly. That fly is in love with whatever makeup product she has used, because she has swatted at that thing about 15 times in the last 5 minutes. I am now feeling terribly bad for this attorney, because being focused enough to deliver this opening to a jury, not easy. Doing it while swatting at a fly that's continuously pestering you, that is torture.
In this case.
So
And the
we
only
know
thing
what
the
it
police had
costs to hire a hitman from this. What do you think it costs to hire a fly?
Don't even. Why is it op? Come on. Come on. Oh, that's just, oh, that's come on.
released to the public at that point was a photo of the light-colored Prius that fled the scene. Police knew at that point that it was Garcia and Rivera who were in the Prius, but the public didn't know that yet. So that fact is interesting in light of some of the things that Charlie Adelson started saying to McVanois. He starts giving her several analogies involving rental cars being used to commit crimes. He reassures her that the police can't prove a person committed a crime just from someone's DNA being in a car that was used in a crime. In order to prove someone committed a crime, you have to be able to put the person at the scene of the crime at the time it was committed. So he's trying to reassure her that even if they identify who rented that car that fled the scene, they still would not have enough evidence to hold anybody responsible for this murder. Charlie Adelson also says that crimes are tough to prove unless someone actually witnessed the suspect commit the crime, or the suspect confesses to the crime, or a suspect is caught on a wire talking about the crime. So he's trying to reassure her about the lack of evidence in this.
No. That seems like you might have been a fortune teller, Charlie.
Case about no witnesses, and trying to let her know that, hey, as long as we all stay quiet and nobody confesses or gets caught talking on a wire, then we don't have anything to worry about. And he begins educating Catherine McVanois about how blackmail works. He tells her that, hey, if this is a guy who knows information, there's 2 ways of dealing with this guy. You know, we could call the police, but then the guy blackmailing us could be charged. And then that blackmailer is going to start talking and the police are going to be asking questions about what happened. The other option is to pay the blackmailer, but let him know that this is just a one-time thing. And we'll try to scare him off by saying, if you come around again, we'll go to the police. Charlie Adelson gives McBanois very precise instructions on how to deal with the blackmailer. He tells her to call the blackmailer and tell her that my friends, meaning the Adelson family, have no idea what you're talking about. And I'm just going to give you this money as charity, but don't contact these people again or they'll go to the police. And Charlie Adelson said he would give McBanois the $5,000 to pay off the blackmailer who approached his mother, except that he's concerned that this guy won't go away. He'll get that $5,000 and then he'll just keep coming back for more money. We'll see him as an easy target. And so Charlie Adelson then offers that the best solution might be to have the blackmailer killed and that he's willing to pay whatever it takes.
Awesome. Just phenomenal. Brilliant criming. Also, I very much appreciate how she is putting together the evidence at this point. It's not like the sent a text message on blank doing this. Now you're actually giving a pretty good preview. This part of the opening, when she's hitting her flow, like, this is solid. And now just each one of these bricks just starts just clunk, 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 and you're going, okay, this is gonna be fascinating.
He says, so help me God, if they F with my family, it's gonna be Nazi shit because this will be done. I mean, Katie, I don't care what I spend. And after hearing that Charlie Adelson wants someone killed and is willing to pay whatever it takes to get it done, McBanois then asks Charlie Adelson to help her out. And Charlie Adelson reassures her she'll be taken care of and reminds her she's on salary at the parents' dental practice. After Charlie Adelson finishes this meeting where he's getting McBanois to then solve the problem of the blackmailer, they say goodbye. He gives her a big hug that's captured on camera outside by the FBI. And then Charlie Adelson immediately calls the defendant to let her know everything's fine and he has handled the situation. He does this using some pretty obvious code words that you'll often hear these conspirators use to mask the meaning of what they're talking about in case law enforcement's listening. McBanois then, also using code words, calls Garcia, and she tasks him with calling the number on the paperwork and finding the identity of the blackmailer. And in the series of recorded calls that y'all are going to hear later this week, you'll hear these conspirators talking and using words like TV, relationship advice, false leads, listings, patients, properties, clients, rap songs, CDs, pigs, all these terms that are obviously normal words, but they're used in context that if you're listening to the conversation don't make sense. So after that undercover operation was over in 2016, Luis Rivera and Sigfredo Garcia are arrested, and they're charged with the same charges before y'all in this trial. Luis Rivera, who was the second person in that Prius.
Those two look like they would never flip on anybody, right? They look like steel traps, don't they?
I mean, really, if somebody's going to kill for money, they will absolutely flip for, an advantage.
Yes. They have already demonstrated that their services can be purchased. It's just a different form of currency when you're facing incarceration.
Cut a deal with the state and told law enforcement the truth about the murder of Dan Markel and the people responsible for it. He told police that he was hired by his longtime friend Garcia to help kill Dan Markel. Rivera described how Garcia told him that this was a job that McBanois was able to get for them, and it was in Tallahassee, and it paid $100,000, and that Rivera was going to get a third of the money. Rivera said that during the trip to Tallahassee, Garcia had a piece of paper with a picture of the man that they were hired to kill and some handwritten notes. And during that trip, Rivera said that the first call that either of them made after the homicide was from Garcia to McBanois, where Garcia told her that the job was done and McBanois assured them they would get their money the next day, which they did. That McBanois brought the money.
Don't nod at the prosecutor's opening. Really? Was that happening? I missed that. Was that just a tick? I have to rewind. What are you doing?
Where Garcia told her that the job was done.
Man, she's doing a really good job.
Assured them they would get their money the next day, which they did. That McBanois brought the money the next morning to Rivera's home. And law enforcement checked
This might be an I can work with this nod.
It might be. It might be. I still hate it. it doesn't mean it makes it that much better. Don't nod along with the prosecutor's opening. Didn't expect to see that. All right, so sure.
Phone records which corroborated Rivera's information. Law enforcement told police that the money that he received from Magbanua the next day was packaged in a very unusual way. The money was basically in stacks of.
Utah would like to have a word with you. Is it me or is it very rarely I see crazy case from any other state than Florida? Utah would like to have a word. I think Idaho also would like to give you a run. Massachusetts is also throwing their name in the hat.
Massachusetts is like, hello.
Yeah, Georgia too. They would like to be heard on the matter. Fulton County specifically. We get some crazy ones from all over. So one thing I've learned about in trial coverage, no one is immune from crazy.
1,000. Each stack was made up of $1,000 bills that were then stapled together. And after each stack was stapled together of 1,000. And after learning this from Rivera, Magbanua was arrested, and that was in October of 2016. During this trial, you'll hear that the Adelson family had access to a lot of cash because their family gave cash discounts at their dental practice. Like if you paid in cash, you would have to pay less than if you paid on a card or check. And they kept the cash that they received in stacks, and they stored it in a safe. Law enforcement also learned from Charlie Adelson's friends that Charlie Adelson had a very unusual practice of keeping his money in these $1,000 stacks that were stapled together, just like the money Rivera received.
By the by,
last few
that
years,
also
since the
suggests that
2016
they were like, why are you giving a discount for paying in cash? Are they not declaring some of those procedures and just kind of?
I mean, part of it is also that there's a hit to the payments and credit card. So for example, the 3 or 4%, whatever that gets charged to the business.
Yeah, fair enough.
Especially if it's a large dollar figure transaction. Yeah, I can see that.
Arrests of Garcia and Rivera in May, and then of Magbanua in October 2016, law enforcement has not stopped working on this case. 3 years after Garcia's arrest in 2019, he was convicted at his trial. Law enforcement continue, though, to gather evidence. They continue to interview people who may possibly have information and to clarify all of these recordings the FBI did that couldn't be clearly heard. And thanks to their tireless efforts, in March of 2022, Charlie Adelson was indicted. 2 months later, in May of 2022, Catherine Magbanua's case went to trial, and she was convicted. During Magbanua's trial, Catherine Magbanua took the stand, and she insisted, this is back in May of 22, she insisted she had no knowledge of the murder. The Adelsons must have just gone around her to hire the hitman directly. That's what she testified to. Her defense team insisted that the state's theory was correct about every co-conspirator except for her, for Catherine Magbanua. That Catherine Magbanua was just this victim of bloodthirsty and desperate prosecutors. And
oh, isn't that a preview of exactly what this defense is going to do? Like this was really smart.
That was 100% smart.
Just brilliantly placed too. Like, hey, so when they get up and say this, just be mindful that this happened before.
Investigators, and just a victim of this set of circumstances that appeared to prove one thing, but was actually, the truth was something else entirely. However, after being convicted at trial and sentenced, Magbanua finally decided to testify about the plot to kill Dan Markel and admitted that she was the connection between the Adelson family and the killers hired to kill Dan Markel. Magbanua testified in Charlie Adelson's trial in October of 2023 and said that Charlie Adelson wanted to hire someone to kill his sister's ex because his mom was stressed out over all of the problems his sister was having with her ex-husband. Magbanua said Charlie painted a picture that Wendy's ex was this terrible man causing his mom so much stress that she couldn't sleep or eat. Magbanua agreed to help him and ended up recruiting her children's father, Garcia, and also Rivera to kill Dan Markel. She says that the night of the murder, she went to Charlie Adelson's house to pick up the payment for the murder. And when she arrived, Charlie Adelson said that his parents had just been at the house and that Charlie Adelson had the money for her there. Law enforcement was able to corroborate this claim with phone evidence showing that Donna Adelson went to Charlie Adelson's house the night of the murder. Magbanua then spent the night with Charlie Adelson that night, and the next morning, on July 19th, he put the money that she was to divide up into the trunk of her car. Magbanua says several things about the money stood out to her. She said it was stapled together in stacks of $100 bills and that it was damp like wet. She then delivered the money to Garcia and Rivera afterwards. When Catherine Magbanua said that when she asked Charlie Adelson about the money being damp, he said that his mother the defendant had actually washed the money, and that she and Charlie Adelson kind of laughed about the fact that the defendant had literally washed the money so it couldn't be traced. In Charlie Adelson's trial, Charlie Adelson took the stand, and he testified that
they laundered the money, and they laundered it.
Why is this a thing? And why is it that this is not actually the first time that this has happened?
I don't know.
Where somebody's like, how do we do money laundering? Oh, right. In the washing machine.
Yes, because the feds and the police, you know what they're very capable of doing? Getting fingerprints off of money. Said no law enforcement ever. Yeah, no. This was I didn't understand this part. You know, sure, why not?
Garcia
Make sure
and
you
Rivera
launder money
together, but that the Adelsons had nothing to do with it. They were the innocent ones. He had crafted an elaborate story in which Garcia and Rivera came to Tallahassee on their own, killed Dan Markel without his knowledge or his family's knowledge, and then these killers colluded with Magbanua to play he and his mother for fools and extort money out of them. And for many reasons, which will be revealed to y'all in this trial, Charlie's interpretation of the facts was not reasonable to believe, and he was convicted. Charlie Adelson was convicted in November of 2023. And within hours of his guilty verdict, this defendant began to plan to flee the United States to a country that she could not be extradited from in order to avoid being arrested for Dan Markel's murder.
This is also what we call consciousness of guilt.
Yes, this like we might have a debate over whether consciousness of guilt evidence is proper and should be admissible, and whether it really is true consciousness of guilt evidence. You know, for example, driving the vehicle, Karen Reed, when they tried to get driving the vehicle to the dad's house, and like that was somehow consciousness of guilt. What the fuck are you talking about? What are you talking about? Conversely, Googling non-extradition countries, that falls pretty squarely within the definition of consciousness of guilt. This one was really bad. I mean, and what a closing. What a way to bring this all home to this criminal defendant, because you kind of forget for a second, because a lot of this stuff is Charlie and Katie, and then Charlie's talking about the mom laundering the money, and by laundering I mean actually physically laundering the money. But you're kind of wondering, okay, well, where are they getting to the point where she actually did this, or she was involved in this, or she orchestrated it? Because you had the prior communications, and then you have this.
The defendant on her phone researched countries that did not have extradition treaties with the United States, and she applied for an emergency visa to Vietnam. She was overheard planning to put her money in trust for her grandchildren, and she and her husband purchased one-way tickets with a fast-track emergency visa to Vietnam. And Vietnam does not have an extradition treaty with the U.S., as she would have learned from her searches. And just days later, she was stopped by law enforcement on the jetway in Miami International Airport, where she was boarding her one-way flight to Vietnam. And she was then charged for her participation in the murder of Dan Markel.
I mean, it does not get worse than that. Like among the things that you could have as a fact that's elicited at your trial, being caught attempting to flee after having searched non-extradition countries, applying for an emergency visa, buying a one-way ticket, and being caught with tons of cash on you, is probably the worst factual. I mean, there are jurors that, even though they shouldn't, there are jurors who would completely convict on those facts alone. Right? Like, with what you know about juries.
Yeah. After the defendant was charged, law enforcement received information from women who said that the defendant, Donna Adelson, was offering them bribes in exchange for
I forgot about this part. Somehow it gets worse. I forgot that it got worse.
false testimony in this trial. They said Donna Adelson promised them money, housing, veneers, prescription drugs, if they were willing to testify that Catherine Magbanua told them a completely different story about the crime than the one that she would be testifying to. One informant was even able to show law enforcement a script a question and answer session for a direct examination and trial that Donna Adelson herself wrote, and that Donna Adelson wanted this informant to memorize and come into court and perjure herself by reciting it to you here in trial. Please listen to all of the evidence that y'all are going to see and hear.
This is the dumbest thing. I don't know that there was the walk the dog letter, right? That was stupid. Corey Richens, where she wrote the letter telling, walk the dog, horrible letter, really dumb, absolutely admissible. And then there's handwriting, like in your own handwriting, a script for a possible question and answer with law enforcement. That you're then bribing people to come out and say, if you're a prosecutor, like you might be looking at all this other evidence, you're going, yeah, it might be thin on this one, this one, this one. But holy
you add
shit.
up all the, yeah.
Here in this trial. I know it's been a long week already, and we have a lot of evidence for you in this case. But when you do, you will see that this defendant conspired with her son, Charlie Adelson, who solicited his girlfriend, Catherine McVanois, to get this murder done. And then this defendant paid her with cash, with checks for the job once it was completed. The defendant acted in furtherance of this murder plot that went beyond just thinking about it or just talking about it. And these acts make her guilty as a principal to first-degree murder, just as if she was the one pulling the trigger in the garage herself. And while the defendant's choices helped solve a problem within her family, they came at a very high price. She took the life of a loving father of 2 little boys and caused a lifetime of grief for Dan Markel's loved ones. And at the conclusion of the evidence in this case, you will be convinced beyond any reasonable doubt that this defendant is guilty. And at that point, we'll ask you for the only verdict that does justice in this case, which is a verdict that this defendant is guilty as charged. Thank you.
It's a really good open.
Just so solid, like rock solid open statement. Like that is textbook. It's completely textbook in that it's well put together. It's well organized. It doesn't dwell on too much. It doesn't go into too many tangents. It's written, and it does come off as it's delivered as written, but it's written because it's a complicated issue and you have to go through a whole lot of detail. They took a remarkably complex case, gave an opening statement that began at 42 minutes and ended at 1 hour and 36 minutes, under an hour for an opening statement for this complex of a case. That is a damn good job. So I thought that was remarkably impressive. So they did all of that. Let me catch on some of these, make sure I'm not missing anything on the other super chats and questions that I wanted to pull up. Some of these I'll have to get to a little bit later. Let me see. That means the boys probably don't remember him. They're given the age of the kids.
That's
the
rough.
family, the kids, this family was probably absolutely devastated. You have the kids, you bring them through the traumatic experience of a divorce case, divided household, and then you do something like this. This is absolutely horrific. This is not funny, but it did kind of make me chuckle a little bit, probably inappropriately. Skeesy, someone in our county stole the catalytic converters out of so many school buses, they had to shut the school down, and the kids are back to e-learning for now.
Sorry, it is kind of funny.
There's a part of it that's a little bit funny. It's really fucked up, but it's kind of funny. Emily Hart, Harvey found his way to the courthouse by himself without Donna holding his hand. Harvey being there is kind of wild to me. I get it, but there's way too many references to his name in this for me to be comfortable having him at that courthouse. Mary Coppola, don't ban me, but Jackie Fulford, who's the defense counsel, is about to get up and start talking, reminds me of Granny Clampett from Beverly Hillbillies. I don't know that I would make that connection. Sure. I will say, where the prosecution ended with their closing of remember the fact that this person is just as guilty as the person who pulled the trigger and deprived the boys of their father. I want you to remember, because that's the closing remarks by the prosecution. And when you hear that from the prosecution, in your head, you're going, there's no way, the defense is going to start downplaying a lot of the involvement, right? They're not going to go straight in and start talking about the victim. There's no way. Well, you would be very wrong. The defense opening is
I
rather.
was like, it's a weird opening because it basically says we're all on the same side, and I'm like,
I openly cringed a couple of times, and I was openly just going, "Are they serious right now?" I'm going, that's a decision. This is back down to real time, so we can just get a
educate himself
measure
so
of
that
what's
he could
happening.
get here at the law school.
Wait, why did that cut out? Did Court TV lose their feed for a minute? Do I have to go find?
He worked very hard so that he could get here.
Oh, guess Court TV lost their feed for a minute. Hang on, let me find a different one. Hang on, let me pull this back down. Let me find the. Let's do this. So Court TV's feed apparently did not pick up. This is Tallahassee, right? Adelson trial live. What's the local in Tallahassee? WCTV. No, I'm not gonna do. I won't do law and crime. Just out of principle. Tallahassee Democrat, but they don't seem to have. They seem to have snippets of it. Oh, they have. Do they have the full thing? Okay, let me see if I can't go to them. Thank you, Emily. I like the live. I like the local coverage, just because they usually will stay on it longer and they don't cut away. But sad part is they don't timestamp. Like Court TV has been kind enough to start timestamping stuff. So let's do this. Got to boost this audio again. So we're back in court. The audio has not been flipped over. I cannot tell you how much I would want to try a case in front of this judge. Why is the audio not there?
Everyone can be seated. Is the defense prepared to give its opening statement at this time? You may proceed.
My name is Jackie Fulford, and I, along with Mr. Zellman, represent Mrs. Adelson, and I don't think you've heard my voice yet. I'm going to try and talk slow because if I don't, the court reporter is going to scream at me. I just want to start by saying this. Remember, during the course of the proceedings, that the state always gets to go first. The defense has the right to be heard. So please keep an open mind until you hear from us as well. You just sat through an opening statement.
I was like, all right, way to go. Good job. Love the start. Remember that the state gets to go first, but you may be mindful to listen for us too. Wonderful. Off to a great start.
The presentation was pretty cool. I'm old fashioned, so I don't use that kind of stuff, but for an hour you heard about this killing. And we're going to talk about that in a minute. And you heard an awful lot about why they think Donna Adelson has the motive to kill Danny Markell. And you heard an awful lot about what other people did in this case. But not a single piece of evidence was discussed that shows that Donna Adelson planned this, hired anybody to do this, or intended that this happen. And I just want you to be mindful. that when we're at the end of the case and the judge gives you the instructions, and he gives them, I won't do that. When he gives you the instructions, he's not going to give you an instruction that says the state has to prove motive. He's going to give you elements of each offense, and he's going to say that each element of each offense has to have actual evidence to prove that. Not motive, actual evidence that those things happened.
Yeah, and they're sitting on a pile of it.
Maybe you were not listening to the same opening statement that I heard.
Yeah, I heard many things.
I heard a lot of references to a very comprehensive investigation. So sure. And people, this counsel stands a lot further away from the microphone, and I have the volume boosted up 600%. So this is up 600%. So I've got it as high as I can. This one confused me. I don't know if a lot of large creators jump in at the end without knowing anything about anything. Super annoying. There's the true grift, clicks and likes, no actual content. I don't know. I hope it's not referring to me. Like I'm at the beginning of the trial. Like I give commentary on trials. I don't like having background information before I go to a trial because I like viewing the trial as the trial. But hey.
No, I know you all.
Yeah, I suspect this is like, why haven't you been following this for years? And it's like, well, okay.
I actually think
a trial. And you know what the jury doesn't get to do when they're following her? What the jury doesn't get to do? They don't get to go back through all of that.
Yeah, I like doing this because the other thing is I come into this blind with anything going on in Charlie's case. I don't know any of those facts. I shouldn't know those facts because they have to prove the conspiracy on this one. So, if you were complimenting, take the compliment as it is. But I take the observation too. The only challenge that I have is I can't stream all the time. I can't do recaps. You gonna do recaps of this trial? I know you were debating.
So I have a lot going on, including I am doing some I'm teaching some community peace officers who are sort of half police, if that makes sense. So I'm going to be doing recaps, but I'm going to be doing sporadic recaps. I'm going to be doing like,
every couple of days or so.
Yeah, I'm probably going to talk about this tomorrow.
Mm-hmm.
And then Sunday I have to drive for like so many hours. And then, yeah. Monday I have to drive for a ton back. And yeah. So I'm going to be doing occasional like recaps. And I mean, I know people. No, that's fair. Thank you.
I'm calling this out. Thank you for clarifying that. I do notice that. The only reason I was kind of sensitive to it was because when I was covering the Karen Reed case, I don't know. It's difficult. If I feel like I always have to kind of justify because I'm only streaming on Fridays, and it's difficult to play catch up on a whole damn week of trial.
But I mean, people ask sometimes like, how do you decide what to cover? And I decide what to cover purely based on like what interests me. Because, yeah. And so far this trial seems pretty interesting. So that's kind of why I'm planning on looking at it, because it looks interesting.
I think the investigation is remarkable. I'm really impressed by that. I like the prosecutors. They're organized. Some of the fights on some of the evidentiary issues, we'll get to one of them. I do want to cover one of them. Are really fascinating because I'm looking at it going, I can see a little bit of point one way or the other. I also love the judge. So this case has got me very curious now. But let's listen. So defense close. I am doing my very best to get the volume up. I think that within about 30 seconds to 60 seconds from this point, the audio, whoever was handling the court feed today, they realized their audio was glitchy. And they started boosting their own audio from their end.
The other thing I got to start doing is planning for the extra life, because it's coming up in so that means I got to make sure all of the stuff from the last year's auction goes out, because but I also need to I also need to start planning for like, what are we doing this time? So yeah, I'm gonna have to start hitting people up for like, hey, would you be willing to come on? Would you be willing to donate stuff? Would you be willing to all of those things? Because I mean, now given that I've been like raising a pile of money each year, it's like, well, I want to keep doing that.
Mm-hmm.
And I do have like a lifetime goal of what is it?
Million?
I have a lifetime goal of hitting 1 million. So that is the thing I want to do. So I got to keep raising the monies. So
It's very kind of you to say. And actually, this is one I want to encourage. I like encouraging. If you are watching a trial on one lawyer's channel and they're doing commentary, I very much encourage you to bounce around. You will find that we will agree with each other on a lot. We'll disagree with each other from time to time on different issues. Usually will track with lawyers will all kind of be consistent on certain viewpoints that we have. But if you bounce around between the different lawyers, what I have found fascinating, if I go back after I've watched something, and I'll go back and I'll watch Peter or Ian or Emily or somebody, and all of a sudden, like they'll give a reaction to like, and they'll catch the same thing, like that just frustrated them. I'm like, that's the same thing. Yes, it's yeah. I encourage it. It's really cool. All right, back to defense.
And you're going to hear a lot of evidence and phone calls and text messages and emails. But I want to ask you to never, ever stop thinking for the 2 weeks or 2.5 weeks that we're here about why it is we are really here. Not just because Donna Adelson is on trial, but because 2 men killed Danny Markell. Don't forget Danny. He was an amazing professor. He was very well educated. He had 2 degrees, I think, from Harvard, one of them from law school there. He was a professor. He had students. He was very well respected by his peers, his colleagues. He traveled all over the place to talk at conferences. They wanted him there for him to come and speak. Very, very intelligent man. And I can't say I know because I never met him. I wish I had. But I know he had to be proud of all that he had achieved.
I do have to say, I find it interesting that she says, I can't say I know, and then proceeds to say, I know. Like, I get it. Like, it's a turn of phrase, but this was wild start to an opening statement. Very, very, very uncomfortable. I think that every lawyer that was watching this just got really uncomfortable.
mm-hmm.
It was his career was important to him. Him continuing to educate himself so that he could get tenure at the law school as a professor. He worked very hard. He earned a lot. What he did not earn was for somebody to do this to him. You're going to hear that Wendy Adelson, the daughter of my client, was married to Danny. And I'm not trying to be informal when I say that. I respect Mr. Markell, Dr. Markell, but because so many people in
Okay, so I did get back over to the Court TV feed, and the Court TV feed has stopped glitching. Well, it has gotten back to the part of her opening, so we are caught up, and the Court TV feed audio is 1,000,000 times better than the Tallahassee audio. So we're gonna go back to this. Maybe 1 second. This is going to be a lot better. So incoming audio change.
At the law school as a professor. He worked very hard. He earned
No.
a lot. What he did not earn was for somebody to do this to him. You're going to hear that Wendy Adelson, the daughter of my client, was married to Danny. And I'm not trying to be informal when I say that. I respect Mr. Markell, Dr. Markell, but because so many people in the trial are going to refer to him as Danny, I'm going to do that if that's okay. but I don't mean any disrespect by doing that. More important.
That,
to
you
do-
know, if you have to explain to the jury that you don't mean any disrespect,
Disrespect, you probably shouldn't do it.
just don't do it.
Yeah. Generally speaking, if you're nervous about how it's going to be perceived, then you should just assume that someone on the other end of that's going to perceive it this way. It's very, very, you know what, Laura, this is a spot on analysis. This is giving me the pawpaw and mags all over again from the Murdoch trial.
God, I hated that.
I did too, and this made me so uncomfortable after probably one of the most effective openings that I've seen from a prosecution case that laid out a very, very, very good case, a very comprehensive investigation, a very strong argument, where I'm walking into this going, usually, you guys know, usually I am very, very much pro defense. Like, I am very much make the prosecution prove every element. I got to the end of that opening and I was going, holy shit, does the defense have an uphill battle? Like, this is insane. There are so many facts. And then the defense counsel gets up and you're thinking they're going to start to lay out how these things are refuted. And no, we're going back to Danny Boy. And don't ever forget about the victim, that two people came up there and shot him. What the fuck were they thinking?
Than anything in the world were his little boys. He had two little children when this happened to him, a 3-year-old and a 4-year-old. When the divorce first happened, when Wendy moved out, he did not want the divorce. That was in 2012.
So now you have gone and turned Wendy Adelson into the driving factor of what broke up the marriage and the family. What the fuck are you doing?
This is weird.
What are you doing? You just said the boys didn't understand Wendy when Wendy left the house. So now I know that Wendy moved out of the house. The boys didn't understand. Like, what the fuck is going on?
And they squabbled during the divorce. They did. Each side argued for their side. The other side argued for their side. That's what happens in divorce. Divorce is not fun. Divorce is not usually friendly. Some of us have had friendly divorces, but not everybody does.
Nobody cares about your divorce.
And a lot of things were said. But moving forward to 2014 is where we're going to concentrate on, because that's when Danny was killed. And in 2014, with these little boys that he had, the divorce had been over for a year. Relocation, the opportunity, even discussion about it, ended. On July 31st, when the final judgment was entered, relocation was over. The state told—
Yeah, let me tell you from the context of a divorce attorney, let me tell you how many people accept the judgment as being final, and how many people are like, I'll just go back and relitigate this again. This is just terrible.
Rob, do you have some opinions?
This is so stupid. This is so just disingenuous. And let me tell you, if there is one juror who's been through a nasty divorce, if there's just one juror who's been through a nasty divorce, oh my God, this is so dumb. This is so dumb. Yep.
told you that. The court denied it with prejudice. She could never raise it again. No.
Hang on, you threw the air quotes around the wrong thing. Look at this. Look what she air quotes.
Opportunity, even discussion about it,
Ready?
ended. On July 31st, when the final judgment was entered, relocation was over. The state told you that. The court denied it.
Did you see that? You just threw air quotes around the court.
Wow.
What the fuck? Oh my God.
With prejudice. She could never raise it again. Nobody was fighting anymore about where these little boys would be. Danny advocated for not only himself in the divorce, he advocated for his children. They are an important part of his life. He wanted as much time as he could get with them. They ended up splitting the time equally between Wendy and Danny. Their schedules changed a little bit on how they worked that out, but it was 50%. This bug is driving me crazy too. What in the world is that? Sorry.
Told you,
He
equal opportunity test.
continuously, from the time Wendy moved out till the time that he was killed, spent as much time as he could get with his children. He loved being with them. If it wasn't his time to have the children, he would go to their little preschool and spend time with them there. He wanted to talk to them on the phone as much as he could. You guys are way younger than me, so maybe you don't even know about this, but I guess there was a thing called Skype. I don't even know if it still exists, but I guess it's like FaceTiming, but doing it on your computer. And that's how
Anyone else?
lawyers stop just like dunking on themselves for being old and not understanding technology challenge.
This is so stupid. I hate everything about this club. I was listening to this opening statement and I was like, well, this is a choice, but I didn't have like open, like hearing this for the second time today. This is horrible. This is a train wreck. This is an absolute undismitigated disaster. Nothing about this is logical or makes sense.
She's got nothing to work with. And she's managing to dig a hole with it, but
that's the point. Like, that's what I'm talking about. She's got nothing to work with, but she's got a shovel and she keeps on digging.
it's
What
like,
are you doing?
she started with nothing and she ended up with less than nothing. So
she's talking about like how this father loved to spend every waking minute he could with his children.
I think that her angle here is basically to say, look, Donna Adelson loves them too because I'm talking them up. And
it's not working.
It's not working.
What was this? She has fashioned a shovel out of words. She has.
I like
this
this
is
one.
a tough case, Merson. I'm buying timeshare. it maybe. I think timeshare presentations are less cringe. This, you know what?
False.
Ready? Wait, hang on. Nail, meat, head. Ready? Hitting the nail on the head. Getting Elaine Bredehoff vibes quite strongly here.
Yeah.
This is rock solid. This is a solid. Yeah. Very similar in what the fuckisms. So, is she going to tell us about MySpace next? Oh, the Book of Faces. It's the Book of Faces. It's the Book of Faces. The Faces book.
he wanted to talk to his kids so that he could see them when he wasn't with them while he spoke to them. Now, at 3 and 4, it's kind of hard to wrangle them to sit down in front of a screen. So Danny came up with a really good idea. When he Skyped the children, it would be most of the time after the kids had had their dinner and had their baths where they're kind of calmed down. They're not in their little running around state. And he would read bedtime stories to them. And he didn't have his little kids. He still wanted to know that when the children went to bed, they didn't forget about Daddy.
Okay, so I don't know a whole lot of things outside of the facts that are taking place in trial, but I have seen it fly by in the chat, and I did take a look at a little bit there. One of one of the big issues is, my understanding is that the dad's parents have had no contact, like not with the kids, and they've been denied any request for contact, and that the court via pretrial order has precluded any reference to that fact by the prosecution. This counsel is coming dangerously close to opening the door to those things coming in. Like, this is inviting familial interaction and allegations of familial interaction and familiar intervention to prevent interaction. So this is getting dangerously close to allowing this in. And we'll see. If I'm the prosecution, I have gone back to the drawing board, and I have crafted a motion that I probably plan to present to the court on Monday, saying, hey, by the way, the defense in their opening statement kind of kicked the door open on this one, and I'd like to introduce all this evidence. Oh, and apparently they changed the children's name last year from Markel to Adelson. Cool. This is wonderful. I think this is just fucking A.
I mean, that'll totally help, but you know.
Oh, did they file a motion? Please tell me they filed a motion. If they filed a motion and I just didn't know about it, but somehow predicted it based on this opening, that's going to be very interesting.
And he made sure that didn't happen. These kids are not deprived of their father. Their father was brutally taken from them. Not
Whose side are you on?
I don't know. What was that? They were not deprived of their father. They were brutally. You know what else I'm doing right now? If I'm the prosecution, I am grabbing.
I am not doing anything, because it's like, wow, that's maybe objectionable, but there is no universe in which I'm objecting to that, because those are all the things I wanted to say, but I thought that I would get objected to. This is now the very first line of my closing argument. I will agree with one thing the defense said to you in her opening statement, and I'm going to repeat it right now. The defense said to you in her opening statement, these children were not deprived of their father. They were brutally taken from them. And now that you've seen this evidence in this trial, we know that Donna Adelson is guilty for that fact. And it just, what the hell were you thinking? Her client's sitting there like, I have the worst lawyers.
Her client, I think her client is buying it. Our client's buying in this. She's the one crying there like crazy. Like,
maybe that's the point.
Simple
is
country
to just have
lawyer
the
all over
client,
again.
You know, so that the client can cry during this.
I don't know. I see comments about her, and I'll get to the comments. I think there's an article out there about it, and I'll go over it after the closing or after the opening. This is pretty wild, though.
just when they were 3 or 4 or 5 or 6 or 7 or 8, but up into their teens, they lost the opportunity because someone took it from them to grow up with a father, to have his involvement and influence in their lives, to talk about what he did as a kid and share his experiences. All of that was stolen from him. That's very important. This Skyping that he did with his kids, Mrs. Adelson, when she had the little boys, actually arranged so she could do that with him. And she would keep the kids in front of the screen while he talked to his children. You've heard a lot about how she hated him. She said some ugly things during the divorce. Pretty foul things, actually. But you're going to learn through the evidence why that was occurring and how she was actually interacting with Danny. They're 2 very different things.
Yeah, because one she was saying behind closed doors to her family, the other one she was saying around him and on a Skype call or on video that she knew was going to be presented to a judge in family court. Yes.
Yeah.
Yes. I completely understand that she probably said all the cool and nice things when he was present, given the allegations of the divorce case. This prosecutor is probably like, oh my God, this is amazing. This is the best opening statement I could have. Oh shit, it's not my opening statement.
I want to talk to you now about my client, Donna Adelson. She is a
And Donna
normal
Adelson's
person,
like, no, please don't.
just
You've done
like
enough
all of us.
damage.
At the time that this happened, she was 64 years old, married to her husband, Dr. Adelson, a dentist. Now they've been married 54 years. It was somewhere in the 40-year range when this happened 11 years ago. And she got up in the morning and went to work, not at her and Harvey's business, like you were just told. She went to the business owned by her son. Every morning, they got up and they went to work. She did the books. She kept the books. She greeted patients. She got charts out. At 7:30 every morning, she was there and organized and had everybody ready to go because they had a little staff meeting. So everybody could know what to expect, what patients they were going to see, what they were going to take care of. She was there working, sometimes late into the evening, just like all of us. She's a normal person. People who
It's not a
know
good place to
Donna
be when you have to convince the
will
jury she's a
tell
normal
you
person.
that
No.
she is not the person that the state is portraying her to be. She's kind.
Are you going to introduce character evidence? Please tell me you're kicking that door wide open. Did she just say that she's going to kick the character evidence door open?
Apparently.
Wow. That's a move. In a criminal case by a defendant. Hey, Ian, when you have a client that says, hey, I would like to have someone testify to my good character and my good nature and how I'm not violent or a bad person, do you ever let them do that?
No.
And why?
Because like there is no person who has ever been good enough for that to be a good idea.
Let me put it this way. Would the Crown be able to introduce evidence of their bad character if you didn't
Oh
open
yes,
the door?
once character is in evidence, then
but they need you to open it, right? They need you to open it. They can't open it themselves.
Character cannot be introduced until and unless the defense says character is at issue. And once the defense puts character at issue, then the prosecution gets to do it. And and you know what that means? The prosecution will say,
hold my fucking beer.
I am gonna need I'm gonna need some more time. And I'm also going to need to recall every single one of my witnesses.
Yeah. Yeah. Like there were 4 pages that I was not allowed to get to as far as questions that I can now get to. So yes, we will have a rebuttal case. And judge, can you give me like 5 more days? No, I'll take 3. Like just
you could be like your client could be Mr. Rogers, and they will like find somebody who hates Mr. Rogers, right? They will find somebody who is like, well,
there's a bad analogy. You could say my client was like Bill Cosby before we found out Bill Cosby was Bill Cosby. There's a good example. But judge, he's got the character of Bill Cosby. Bill Cosby before we knew about everything, or Bill Cosby after we knew about everything.
Yeah.
This is.
I don't think she's opened the door yet. Like she's just made a comment, but like, oh, please go ahead. Like they will, yeah. They'll just be like, all right, we're just gonna go to town.
It is pretty wild. Alyssa ADT, was that a lip lick of disgust? I can't. with openings and statements like this, I haven't been able to watch them long enough to be able to look at anything they're doing. I will say that there's a whole lot going on here that is just really uncomfortable.
Yeah, and I mean,
Caring?
this is like, this. There's a reason why defense openings are almost always like, look at the evidence they don't have.
Mm-hmm.
And what they almost never do is like, look at how awesome my client is. Because as a defense lawyer, your client usually isn't awesome. There are exceptions to this. Like sometimes you'll talk about your client being like ordinary, whatever, in like a self-defense case. Today, my client woke up, they had an ordinary day ahead of them. They didn't expect that any of this was going to happen. And they just set out and suddenly, and then you talk about your client or being really for a self-defense case. You don't want to talk up your client as being like the best person ever. You talk them up as being the boringest, ordinariest person ever.
Mm-hmm.
Right? Like this, my client is the everyman. Because, what you're trying to hint at that point is you're trying to say this could happen to you, jurors.
Can't say that, but you can try to get to it.
You can hint it.
You dance as close to that fire as you can possibly get.
And the way you hint it is this guy is Joe Ordinary.
Yeah. Doesn't he sound like you?
Yeah, exactly. So,
yeah. Whoever 420, no one is awesome enough for a court of law. Absolutely factual. 100% true. 100% true. I meant tongue jut, I think. We can watch I've been trying to, I don't like reading lawyers because lawyers don't really give me a lot. It's the witnesses that I'm very curious about and when they're testifying honestly. For example, the criminal defendant who was the convict who testified, probably some of the most honest testimony I've ever seen given. He was awesome. He was my favorite so far all day. It was just like, yeah, no. Oh, my favorite part of the day. Well, I guess I'm not gonna spoil it, but there's an accidental discharge of a firearm. Did you not hear this part of the testimony, or did you know that?
I'm just eyebrowing.
Yeah, this defense is Katie Hewling. I tell more direct stories than this opening on my worst ADHD days.
Mm-hmm.
Facts. Absolute facts. Yep. Very much true.
Also, interestingly, Vietnam apparently now does extradite some U.S. Fugitives.
Oh, it would have been even. I mean, it's just, yeah.
That would have been even funnier, though, for this.
Yeah.
She cares more about people
Kind of.
than she does about herself.
Oh my God.
She does care more about other people
Now, what
than
happened
she
on
does
July
about
the
herself,
18th
but
of
she cares about
2014?
killing them.
You've heard the state describe it,
God.
but I want to talk about it for a minute.
She wants to kill other people more than she wants to stay out of jail. It's a thing.
The state is going to be able to prove to you some of the things they were talking about. Can everybody see it okay? No? Oh,
Clearly. Thank you.
thank you. Thank you. So the state told you that he got up every day, just like he normally did, on July the 18th of 2014. And I just want to say this also. Throughout the trial, you may hear me say that he was murdered on that date. Somehow he survived for another 11 hours. But in my opinion, all the evidence is going to show that what killed him took place on the 18th, and he was just able to survive long enough into the next day. So on that date, July 18th of 2014, These two men, Sigfredo Garcia and Luis Rivera, followed Danny all over town. Started at his house, followed him to the school where the little children were going to school, the preschool where he dropped them off, watched him drop those kids off, followed him to the gym.
I just saw the visual. The minis can create this. I am now going to employ the minis to create my courtroom visuals for now on. What the fuck are we looking at?
I mean, it's not bad.
It's a stack. It's word art. Like it's clip art. Look at the stack of cash in the bottom right. It's clip art. This is interesting.
Waited outside the gym for him, followed him to his house, pulled up in the driveway. Mr. Markel is talking on the telephone to someone, and he notices someone's coming into his driveway. And while he's talking on the phone and says something about needing to see who this is, he turns and looks in the direction. And this man, Sigfredo Garcia, is holding a revolver. And he points it at him. And you may hear testimony that there's some evidence that maybe he tried to, what you do in defense when somebody's going to hit you or whatever, you put your hands up. He saw this man.
Why are you highlighting this?
Similar to this at him. And in that instant, I cannot fathom how terrified he must have been when this man shot him. Not one time, twice.
Yes, you may. This is the defense. This is the defense. This is the defense opening statement.
It would take a real sick twist to do this kind of thing.
How could anyone ever possibly? How could anyone ever orchestrate or wish for this to happen, or perhaps pay money for this to happen? What the fuck are you doing? What is wrong with you? Why are you doing this?
One of the shots is almost right between the eyes. He was brutally murdered by this man. This man, Luis Rivera, who you've heard them mention in the state's opening.
The prosecutor is sitting there like, is this happening?
Is a picture of the car, and the state's going to show it to you. This is the Prius that they were traveling in. This is a surveillance photo that the investigators were able to find to know that it was a Prius that they were looking for. This man supplied the gun and drove the car following Danny, drove it up into the driveway less than 3 feet away from Mr. Markel, whose engine is still running, and he's on the phone. And he waits while this man kills him. He hears the shots. This guy, Mr. Garcia, runs back to the car where Mr. Rivera is in the driver's seat, and he's the getaway driver. Supplies the gun, knows what they're going there to do, kill him, and drive off. They drive off. The state can prove that about Sigfredo Garcia and Luis Rivera. But they're not on trial here, right? You heard they've already been on trial. Then you're going to hear, as the state said, that they can prove that everybody can see, okay? They can prove that Katie McVanois, her name's Catherine, some people.
Oh no, we can see. We can see.
But
nope.
then
Counsel,
you're going to hear
can
that
you,
the state says they can prove.
Can you pause the digging and move the shovel out of the way? I'm missing the bottom right-hand graphic that shows your son and the cash. So like, just take the shovel that you're digging. Yeah, no, don't throw the dirt on your client. That's for later. Take the shovel that you're digging the hole with, move it to the side because I'm missing the cash graphic in the bottom right. I'd like to see that, please.
At this point, she's digging with dynamite.
This is, yep. She hit some granite because she had dug so deep, and she's like, you know what? I should stop right now. Fuck it. Give me the dynamite. Here we go. Dynamite came in the form of a blue poster board that was put together by, I don't know, just a child. What the hell is happening?
Katie. They can prove that she's the one who set it up. This is the father of Katie's children. This is his buddy that was recruited to go along on this trip to kill Danny. They can prove that she arranged these guys to do it, and that she's the one who paid them the money that was in stacks, stapled, $100 bills, all $100. Well, there may have been something other than $100 bills, but each stack was $1,000.
Oh, we're gonna talk about the cash that we all know that you had in the property. Mama MSN, I don't blame you for mistaking this. Didn't this DA get fired from her judge position? She's actually defense counsel, so she's not the district attorney, but I can understand why you would make that conclusion. But yes, she did get terminated from her judgeship.
Stapled together. And you're going to hear testimony that that's exactly what he did with his money. He kept it and saved it for a long time. And you're probably going to hear testimony that this happens on July 18th. And on July the 19th, Mr. Adelson, Charlie Adelson, which is her son, gave approximately between $130,000 and $138,000 that he had in his safe that he collected and stapled together. His money went to her, not Miss Adelson. They can prove and have that he paid her to get them to kill Danny Markell. That's what they can prove. And they've done it 1, 2, 3, 4 times.
Oh, please tell me how many trials they have had and how many people they have convicted in this conspiracy. Seems like they've got a pretty good record at this point in time. 4 for 4 is pretty damn good. I would say they probably wouldn't be going for 5 if they didn't have the goods. Grim Fated. We would give a lot of deference. I can't imagine that I don't know that anyone's gonna really get up and do this one. This is I don't know if there was whiskey consumed before we started talking or not. I'm not sure. So confused. Jesse Waldorf, blues, the official color of kindergarten art projects. It's the official color of the defense project as it is.
This case is really a lot about theory and motive and not evidence. The state has a theory, and for the past 9 to 11 years, in fair.
Oh, this right here. So many bad defense in this case, but I've heard no ideas of a good one. Rob and Ian, any ideas? This right here, where she says you can't convict someone based on motive alone. It's pretty good. Talk about the lack of evidence. Also pretty good. Talk about a lot of things, but talk about those things at the beginning when the jury is listening to you, not after you have highlighted how wonderful this man was and how good of a father he was and how brutal the murder was and how, oh my gosh, the state has these people dead to rights. Talk about that early on. And then you sit your ass down and you poke holes where you can. I missed the glitter on the chart. There is no glitter. Well, there could be. I don't know.
It's probably 9 years. They have told the whole world that Mrs. Adelson was the reason that this happened. Mrs. Adelson was the reason that this happened. They've told this story, and it's outrageous.
This is also really stupid. This is really dumb. I'm going to replay this at real time. And I know that people are probably like, hey, we've heard enough of this. No, I'm going to play something. This is something that caught my attention multiple times because she does it here and she does it the next statement that she makes. Ready? We're going to rewind for a second.
It's people's.
Ready? Here you go. Let me know if you can catch something because this is a speech thing and something that I try to teach young lawyers to do. And I make this mistake. Every lawyer makes this mistake. But listen to how she phrases this. Ready? Listen.
Happened. Mrs. Adelson was the reason that this happened. They world.
Wait, what?
Mrs. Adelson. They asked 9 to 11 years.
Ready?
In fairness, probably 9 years. They have told the whole world that Mrs. Adelson was the reason that this happened. Mrs. Adelson was the reason that this happened.
Why are you telling the jury that?
Lesson.
You're
If you are
their
going
head.
to, if you are going to repeat a statement for emphasis, and that statement has a very massive clarifier, they have told the world that.
The way to do that would have been for the past however many years, they have told the world that Mrs. Adelson is responsible for everything that happened. Mrs. Adelson is not responsible for everything that happened. Like, don't.
You don't do that. And she does it multiple times. This is just terrible advocacy. And it's a lesson that you try to teach lawyers that you never know. And here's the thing. You never know when a juror's ears are going to perk up. You never know when a judge is going to start paying attention. You never know when someone is looking down and writing notes and all of a sudden they are thinking in their head, did I just hear something? And then you repeat the wrong part of the thing that they just heard.
They've told this story, And it's outrageous. It gets people's attention. It's made a lot of money for the media, interviews, specials. Some people in jury selection said they had watched these specials. Lawyers on there, investigators on there.
That's improper, by the way. That's very improper. You are not allowed to do that. Like, you are not allowed to talk about other jurors, and you're not allowed to also, that's also offering to the jury to go and look out public media. That should have garnered an admonition from the bench, to be quite honest. Like, tell me a judge wouldn't cut you off and say, wait, Mr. Runkle, hang on, stop. Jurors, I want to remind you that you are not to look at any media coverage of this case at all. People are asking to play that back. This is a bad lawyer.
Also, the media is entirely unruly, like, is entirely irrelevant to her. Like,
you also can't talk to the jurors about the other jurors that were potentially to be seated in that seat. You can't go into that. What the fuck are you doing?
It gets people's attention. It's made a lot of money for the media, interviews, specials. Some people in jury selection said they had watched these specials. Lawyers on there, investigators on there. They made a lot of money for the media, and it got big attention because this is outrageous, what happened. It is truly outrageous. But what's more outrageous is, without any evidence, only motive and theory, they put her at the top of this pyramid. She's the matriarch. She's the matriarch mastermind behind Danny being killed.
You gave the prosecution their fucking closing argument. You gave the prosecution every line they need in their closing argument. The matriarch mastermind. That's in the headline of this. It is in the heading of this video. Matriarch mastermind. And what's crazy about this is it was a tagline used by the defense.
Yeah. And she keeps saying the thing in the way you don't want it to be said, right? You know, you got to make sure you put, she's not a mastermind. She's just an old woman, right? Like that kind of thing.
So bad. This starts off crazy and it gets worse. Oh, come on, Rob. The prosecution should do better close. Yeah, they will. But still, come on. You're telling me you would pass up that opportunity to use defense counsel's own words in your closing argument?
Oh,
100%. You get a smirk from someone in the... Absolutely, I'm using their words. This was horrible.
And they don't have evidence of that. That's what's outrageous. It's outrageous that he got killed, but it's also outrageous that we're sitting here with a jury and you're going to hear a lot of theory, a lot of motive, and a lot of what they believe the evidence means. They don't get to decide that. The evidence is what the evidence is. And I ask you to patiently sit here and really pay attention to all of the evidence that you hear, every witness that they put on, every piece of evidence that they present to you, all of it. Don't, for 1 second, I'm not asking you to ignore any of that. Please listen to all of it closely. Look for what they actually have as evidence that Mrs. Adelson planned.
And we know that she wasn't ad-libbing this. Look at all those pages she just flipped through. She just flipped through a lot. So she wrote this ahead of time. This isn't just like spitballing. Like this was planned. This was her intention. What the fuck were you? Did you game plan this with anybody? Did you go out into public and be like, so this is what I'm thinking of doing for my opening statement? There's no way.
Planned Danny Markel's murder, that she engaged these men to kill him, and that she gave the money to her son to give to Katie.
Why are you repeating their theory? Why are you repeating their theory and pointing to your demonstrative to emphasize their theory?
Because she is a moron. And because she is a moron.
You're putting the emphasis on their theory. What are you doing?
You won't find evidence of that. The evidence about the $3,000 a month, I have that here on this board. $3,000 a month. Charlie Adelson gave $2,000 a month, and he instructed his mother, for reasons you're going to learn in the trial, out of his business account to put her on payroll. She worked for him, and she paid that money. It's this man's money, not Donna Adelson's. At the end of listening to all of the evidence, we're going to have an opportunity to make closing arguments. And the judge is then going to give you, well, he's going to give it before, he's going to give you all of the instructions on what it is that you have to decide. Did the state charge and then prove that Mrs. Adelson committed a conspiracy? Not one of the elements, all of the
Why are
elements.
you again
Proven by
saying
evidence,
Mrs.
not theory,
Adelson committed a
not motive.
conspiracy?
She did.
For
She did.
each count,
It's like she's done it like 8 times. Like I'm losing count of the times that she has.
Like, you can say it like, did they prove the allegations against her?
So bad. So for every lesson that we learned on how to give an opening statement from a prosecutor, we have now learned how not to do an opening statement from a defense counsel.
then solicitation, all the elements. So while you're listening to the evidence, you don't know what those elements are, but think about what each thing it is that the state has alleged. She planned it. She got people to do it. She intended that he die.
Why are you saying it like this?
This woman wanted to take away the father of her grandchildren for the
Because
rest
if
of their
you
life.
just take
because
that
of
clip,
relocation
it sounds
that
like she's
happened
the
to-
prosecution.
It really does. If there was a juror who was sitting down and kind of got lulled to sleep, you better fucking believe they perked up when they hear that emphasis. It's the most dramatic that she gets.
Yes, and
Year
she's
ago,
getting
when
really
Donna
dramatic
Adelson-
as she
at
says
the end
it
of the
like
case-
she's on the prosecution.
Yeah, I know.
because there's not going to be evidence that she did this. Keep an open mind. Listen to all of it. We're going to ask you to find her not guilty of every single count. Thank you.
Thank you, Ms. Fulford.
Well, that was a decision.
You know what's a better
opening
opening than this?
My client did it.
Not quite that. My cousin Vinny's opening. Everything that guy said is bullshit.
It would have been more effective.
Would have been better.
It would have been more effective. Okay, so let me catch up on some super chats real quick because holy shit. Tag 77, please, pray tell defense. No, she told them exactly how the prosecution theory lines up with her client having a substantial role in this. Anai 3826, they asked for a change of venue a few days ago because of the media. Then she says that I just can't even. Well, I mean, there you go.
You
Light
can't
queens.
even because that opening was so odd.
I don't know that fits in a category of openings. Thank you for the gifted membership. It's very kind of you. Ohio Palm Mom, and this happened because my client arranged it. That's the part that she left out. And I think the prosecution was just kind of sitting there staring at the jury going, you know what I'm going to say, right? Like, you know what I'm going to say? Yeah. Okay, good. We're on the same. Got it. This was starred. Opening statements are not evidence. What if they don't introduce character evidence in the actual case in chief? It depends. You might not get a judge saying that they opened the door, but you can highlight that in your closing argument that they promised to deliver something that they didn't to you. It just brings it back up. ASG 2025 doing speed building practice to this stream. Sending happy vibes this wonderful Friday, working hard to become a CR court reporter every day. Happy FNF to you. Enjoy it indeed. I give court reporters a run for their money. I talk fast. Lynn Britton 391. Oh, and today I had a motion. Today I had a motion where I had 100% of the argument in my favor. I was flying. I looked up at the judge, and the judge was like nodding along, which like encourages you to talk faster. And then I kind of had to catch myself going, nope, stop. They still need to hear words, not just like yeah. Lynn Britton, hey, y'all just got home from football. Replay crew. Love the replay crew. Honk Banana, no. Defense opening should have been Jim McIntyre did it. It would have been more effective. Jim McIntyre. Amy Nickel or Lynn Britton already started that one. Amy Nickel, thanks for becoming a member. Very much appreciated. Jesse Waldorf, later the defense will say every statement was carefully curated. Sure they will. MDL 8767, look into why the defense attorney isn't a judge anymore. I did. I actually pulled that article up. I'm not going to read you the full article, but I'm going to say this. I will recap from the article. She was reported to the Judicial Qualifications Commission. There was a complaint that was filed, 5-page notice of formal charges filed with the Florida Supreme Court by the Judicial Qualifications Commission. Among those were allegations that she helped the son of a significant other in a domestic battery case. She publicly opposed a candidate for elected office using her position to influence attorneys. Those were a couple of the allegations of her conduct. Now, she was removed from that position by the Supreme Court, but they removed her citing a physical disability rather than any of the actual allegations. You can read between the lines as you wish.
Yeah, I can read real good between those lines.
Yep. Lulu Beru, the defense attorney, used to be a circuit court judge, forced to retire in 2015 because of physical disability, but she was investigated for improprieties. I just pulled that up. That is absolutely true. Legalese, thank you for the super chat. Very kind of you. Josiah 9227, not the worst opening I've seen, but the weirdest. It went from the weirdest to the worst for me. No, you're
Still
right.
not the worst.
You're right. To say it's the worst is an absolute that I don't know. There's probably worse out there.
I think we've seen worse. I think Lolly's is worse.
For a defense counsel. Is it the worst defense opening we've seen?
I'm going to have to think about it, but I don't think so.
I don't know. Elaine Bredehoff was bad. But Elaine Bredehoff was better than this. But Elaine Bredehoff was better than this by far. The makeup compact was really bad. But
well, that was bad because it blew up in her face.
Again, a bunch 9191. Please pray for me. My JT with a pro per sov sit. Nice weekend.
You will not have a nice weekend now. Sorry.
Enjoy the prep.
Thoughts and prayers, but
lots of them. Best of luck. Maintain composure. Make sure you get there early and talk to the bailiffs about it, because they just gonna be doing all the craziness. Torin 3, I'm at the point of making specialty tools more often than buying them, but it took a bit to make the mental jump that it was possible to do so. Specialty tool making and craftsmanship is really good. I love that you're doing that, Torin. I know you've been dealing with a lot. Would love to see you back in the shop. I feel you've probably been there. Byron Butterfield, laundering the money seems like a Far Side tune. It was not. It was actual facts here. It was laundered. Sandy, thank you for gifting memberships. Very kind of you. Amy Nickel, thanks for becoming a member. Sandy, again, please take a moment to hit the subscribe button and the like button. Please do so. Like I said, only stream once per week, so I'm not going to bother you too much and inundate you too much with notifications. Please hit the like button and subscribe. Casey Cat, still don't know how Fulford has a law license. She's up there doing her thing. Joy Schmott. Joy Schmay-Har. I apologize for screwing that up. Thanks for becoming a member. Equality. Honestly, I thought Rivera seemed like a nice guy when he was testifying. Luckily, my husband would stop me from being scammed, etc. Rivera, he is shackled. He has one place that he lives right now, and it is not a very friendly place to be. So he has no incentive to lie or say anything whatsoever in one direction or the other. He really has no dog in this fight. Equality. I've been a law lumber member in my 30s and 40s. I'm 40. Congratulations. You made it. You made it all the way there. Tracy Sires, Harvey's expressions remind me of Jeff Dunham's puppet, Walter. Oh, Harvey Adelson. I didn't see him. I know seeing him, but I'll have to keep an eye out for that. Finally freed. My family law case has 560 documents filed since 10 of 2018. Holy crap. Headed to Court of Appeals next. That's quite the contentious battle, my dear. That's rough. I'm sorry for that. I like, clients think that I like the fights that I have. I like courtroom. I like arguing stuff. Do I ever like the fact that my clients are in the mess they're in? No, that's not fun. Catherine EDD, Rob. Hi, Rob, fellow NCSU grad here. Go Pack. Hi, Runkle. Brentwood Chic, I'll be replayed to crew tomorrow, off to celebrate my birthday. Happy birthday. Love,
Happy
love,
birthday.
love that you're celebrating that. Mildred Katie, why the murder charge if she didn't pull the trigger? Oddly enough, the defense counsel is the one that elucidated that. Well, the prosecution highlighted it too during the end of their opening statement, but I didn't expect the defense counsel to bring it back up again. Murder charge because conspiracy to commit. She was right there along with it. So just as the same as pulling the trigger. Wait, no solo cups? No, there were no solo cups. In fact, these solo cups probably had hidden cameras in them that caught very, very good audio and video. So yeah. Voodoo Fairy, I have a Wolf Malamute mix and 40 acres of woods. I leave a phone on attached to his collar. I was out walking the woods with my dog. Not gonna lie, that would be not the worst idea for making a phone not appear like it was just left at home. We are professionals. That's with regard to me. You weren't here for that. I pulled up and I pulled up.
Are you sure that's what that stands for?
I know. No, don't say that. I know the other act, you're not saying that out loud. Hawk Banana, no. I'm here for the unending parade of people pointing out that Markel was a lawyer, professor at FSU, at the equally unending parade of people pointing out that no, he wasn't. Markel was present and teaching at FSU Law, but Peter was not a student of Markel's. So they were same time, not a student. I think he's clarified that. Sandy, please take a moment to the like button. Thank you, Sandy, for reminding everybody. Dancer in her soul, where's Alan Jackson when you need him? He's doing his thing up in Massachusetts. Well, California, then Massachusetts. Vivian James, Dan Rashbaum, watching, thinking, oh, Donna's fucked. This is wild. XCDA, thank you for gifting memberships. Very, very kind of you. Alyssa ADT, if I'm the prosecutor, I'm starting my closing with, I had a closing plan for this, but then I realized the defense said it best in their opening, and then just roll out the quotes. It wouldn't be terrible. Baby steps. Always appreciate your perspective and time. Subscribe since step. I was late to membership. LOL, my mistake. There are no mistakes. Shay B gifted 50 memberships. Very kind of you, Shay B, turning the chat green. As always, one of the coolest supporters of the channel. Lolo, the good dog. When I see this defense attorney, all I see is attorney Tom Petty. Free fallen. So much funnier than I thought it would be. It's pretty good. Kristen M96, Runkle, have you any of your clients offered prison veneers for favorable testimony? It's pretty good. Lola, the good dog. Why all the blue striped shirts? Donna, prosecutor, first witness, all dressed by the Jen McCabe courtroom fashion line. I don't know what the blue striped shirts are. I don't get it. I don't particularly care for it. I think it can be a bit distracting. Katie May B, thank you both for keeping me company while I build IKEA furniture. I wouldn't get it done otherwise. IKEA furniture building is fun and frustrating. Just make sure that you're paying attention enough to do it. Mary Coppola, Jackie Fulford is a retired circuit court judge. And then I think Diddy Truck came in here with a pretty clever advertisement. Moving soon. Save time and money on your next truck rental with Diddy Truck. Compare prices from companies like U-Haul, Penske, and Budget. Reserve your next truck for Diddy Truck, Tech, blah, blah, blah. I will appreciate the grift. I appreciate the grift. It is a very well-earned grift. Thank you. And so do your own research, folks. That was not an ad read. So do your own research. Okay. So we go from that. And then we are quickly, we went through witness number one, who was the neighbor who went out, not a whole lot there, saw him, called first responders, was really pissed off because first responders took 14 minutes to get there. Pretty wild.
Hey, when seconds count, first responders are 14 minutes away. 14
minutes to get there. He was like, it sounded like 14 hours. Dude was solid. Then you got the first officer on scene who reported being there, actually found the gunshot. The round went through the bridge of the glasses, which I've never heard of before, but that was pretty wild. And then the third witness, Joanne Maltese, is the forensic specialist. She's the one who actually performed the autopsy, I believe. And it's during this that we get our little interlude. Was it this one or was it the next one? It was the medical examiner, right? Medical examiner.
I'm pretty sure that was Santa.
Was it Santa that we got the interlude? It was Santa. Which solid beard game, my friend. I mean, that is dedication. And if you are not called Santa colloquially by every single person who's ever met you, you are now.
You may take your seat. Thank you. Please speak loudly and clearly.
Sir, please introduce yourself and spell your name.
I'm Dr. Anthony J. Clark,
Sir, you misspelled clause. I know that it's C-L-A-R-K, but you misspelled clause.
A-N-T-H-O-N-Y-J, Clark, C-L-A-R-K.
How are you employed?
I'm currently employed as Associate Medical Examiner for the Georgia Bureau of Investigation, Division of Forensic Science in the Central Regional Office in Macon, Georgia.
What are your duties there?
I work as an Associate Medical Examiner. I perform what's called the autopsy and forensic autopsies and death investigations.
Is there ever a time that you worked here in Tallahassee as an assistant medical examiner?
Yes.
What time periods did you do that?
It was from 2007 to 2023.
All right. And how many autopsies have you performed during the course of your career?
It's over 8,000 now.
And what is the education and training that you have that qualifies you to do that?
Okay.
Why is she crying at this part?
This is what I mean. This is the part I mean. Like, what? And the comforting. You know what I would be doing right now? My hand would be not visible to the jury, but I would be squeezing an arm, being like, cut it out. Stop it. Cut it the fuck out. Stop it. It's this. The testimony that elicited this remarkably terrible response. The testimony, mind you, this is the test. This is what was just said. Ready?
3.
All right. And
One
how
times
many
three.
autopsies
Normal.
have you performed during the course of your career?
It's over 8,000 now.
And
How many autopsies have you performed? This is sad now. I am now saddened by the fact he's performed 8,000 autopsies.
It's over 9,000.
It was 8,000, Ian. It's not 9,000. That's what's
Yes, but
upsetting.
that's not the meme.
what is the education and training that you have that qualifies you to do that type of work?
I obtained my Bachelor of Science degree from the Massachusetts Institute of Technology. I did 2 years of animal research before moving on to Jefferson Medical College in Philadelphia. I graduated from the college and then traveled over to New Britain General Hospital in New Britain, Connecticut, and did a 2-year general surgical internship. I then went to the Hartford Hospital in Hartford, Connecticut, did 4 years of anatomic and clinical pathology. I then traveled from that program down to Atlanta, Georgia, where I did a 2-year forensic pathology fellowship at the Fulton County Medical Examiner's Office in association.
Did you run out of Fulton County as fast as possible? Is that why it was an internship where you were like, get me the fuck out of here?
He didn't run out. He sledded out.
He slid it out. Emmy Santa is my favorite witness so far.
With Emory University. I am board certified in anatomic and forensic pathology. I have medical licensures both in the state of Georgia and Florida.
Have you ever testified as an expert in the area of forensic pathology?
Yes, I have.
How many times?
Several hundred times.
Tender Dr. Clark as an expert in the area of forensic pathology, Your Honor.
Does the defense wish to voir dire the witness?
There you are.
Is there any challenge to his ability to provide an opinion?
There you are.
Members of the jury, the
Side note, clean. Like, you want to talk about a clean record. Literally says, does the defense wish to do a voir dire to get any information on the credentials? Gets that acknowledgement on the record. Does the defense have any objection to him being offered and presented to the jury as an expert? Get that on the record. And then explains to the jury what an expert is and the qualifications. I was like, oh God, give me more of this judge. I need this judge.
witness will be permitted to testify before you today in the form of an opinion in the fields of both medicine and forensic pathology. You may continue.
Doctor, did you conduct the autopsy of Dan Markell?
Yes, I did.
When was that conducted?
The fuck are you crying about? What the hell is this? There is nothing on her screen, mind you. Nothing.
We performed it on July 19, 2014, and we started at 11:55 hours.
Where was the autopsy conducted?
At that time, we were in the Tallahassee Memorial Hospital morgue.
Did you take photos as part of your autopsy?
Yes, I did.
Would use of those photos assist you in your testimony?
Yes, they would.
Would they assist the jury in understanding your testimony?
Yes, they would.
States 25 through 34. Take a moment to look through those and let me know if you recognize them.
Also, this is the most boring but awesome trial. Like, this is so clean. The questions are all organized, they're concise, they're direct. She has the exhibits prepared and ready to go. She quickly walks up, he flips through them with it. I mean, this trial so far is just a beauty to behold compared to some of the other shit we have seen of late. I compare this to Canton, Massachusetts. I'm thrilled. I'm happy it can be. Compared to Fulton County, Georgia, couldn't be happier.
Yes, ma'am.
Are they fair and accurate photographs that were taken during the autopsy of Mr. Markel?
Yes, they are.
Moving to evidence, states 25 through 34, Your Honor.
There you are. States 25 through 34 admitted at this time.
Publish 25, please.
Before you publish, if the parties can briefly approach.
God, I love this too. And the judge puts it on the record. Yeah. So the judge is already on the bullshit. It just before we show anyone the photos, hey, I want to see all at that side. So sidebar for a minute. Everyone's going, why are we at sidebar? I don't understand. Santa's looking down at his notes. Appreciate the note looking, Santa. Hey, if you're looking through the list and checking it, I do have power tools on there. It is not a misprint. I have been a relatively good boy. If we can maybe keep that in the running. He is looking at me with skepticism right now, Ian. I feel like he can see me through the screen. Oh, I didn't catch the lawyer went back to talk to her.
Yeah, she's having a big sad.
Clark, a brief break.
How quickly it goes. Ready?
A brief break before we continue with the examination of Dr. Clark. The bailiff will take you to the jury room.
Oh, that's creepy. That just dropped, like all of it.
Yeah.
Oh, it's back. Oh, it's gone. Whoa. Whoa. You want to see something creepy? This. Watch your face. There it is. I'm upset. I'm upset. I'm upset. Jury's back turn. Look at the cheeks relax. Holy crap.
Mr. Zellman, Ms. Fulford, if your client needs to use the restroom, this would be a good time to do so.
That's fucking wild. So we're on a break. And we learn why the court's on a break. That would make me furious if I was the judge too.
State, you may resume with your examination.
Oh, wait, so he comes back. Hang on.
Are they still going to the bathroom? Checking on them.
Did I miss it already? Hang on. I think I missed the admonishment. Where is it? Is it?
Still going to the bathroom.
He's seated. The jury's in, though.
State, you may resume with your examination of Dr. Clark at this time.
Oh, it's not the end of the day. It's the end of this witness. It's when the witness is done. Okay, yeah, he puts it on the record after the witness is done. So she kind of cuts the antics.
They are broken up, etc. So we do X-rays, and this is an X-ray of the head. You can see the top of
There wasn't a whole lot.
And is this a photograph of one of these projectiles removed from Mr. Markel's head?
If you remember,
And for the
this is
upper left. Thank you.
on the X-ray is getting a little pretty deformed. You can see that we take one picture, one aspect of it here. Here's the identifying label.
What is meant by the term cause of death?
That is how that person died.
All right, and is it part of your job as assistant medical examiner to determine a cause of death?
Yes, ma'am.
And were you able to do that in this case?
Yes, ma'am.
What was the cause of death?
Got gunshot wounds of the face and head.
And what about manner of death? What's meant by that term?
Manner of death is how what were the circumstances that eventually led to the death.
And do you have an opinion as to the manner of death?
Yes, I do.
And what is it?
Homicide.
No further questions.
If y'all on the oh my god, I can't believe they're just pause game terrible. What the fuck? If y'all don't know how to define, oddly enough, if you don't know how to properly define cause and manner of death after how many trials have you've been watching, what are you guys watching? We should all know the definitions of these by now. You've heard it through how many witnesses, cause and manner of death. There will be a quiz at some point. I don't know when. You know, we should do that for Extra Life, Ian. We should do a quiz. That'd be fun. Like do a quiz for the trials that we've watched. Like which
I'm
lawyer
just trying to think of how you do it.
Well, which lawyer in which trial made this statement? And then like A, B, C, D is an option. And then let the chat chime in.
That is a good idea.
I think it's a really good idea. Yeah, let's do that. I like the quiz idea. Or we could say, what is the cause, or like what is the cause of death, or basically say this and give the definition is either, and then A says cause of death, B says manner of death, like little quiz. That'd be fun. I like this idea.
Yeah, no, it's a good idea.
Definition, Dr. Clark.
No, Your Honor.
Judge, this witness can be excused, and this might be a good time to take our lunch recess.
Very well. Dr. Clark, you may step down, sir. Have a good day. Members of the jury, we are going to take our lunch break at this point. As you have been previously instructed, I'm just going to remind you again, you are not to discuss this case with each other or any other person. During your lunch break, you may eat together if you choose to. Again, you may converse about any manner of things, but this case. Does everyone understand this instruction? Please raise your hands. And for the record, the jurors have raised their hands. Please
He's like, you can talk about anything you want, but
enjoy your
one
lunch
thing.
break.
The wiping away of the non-tears is really, and it's that's not real emotion. This is really stupid. It's really stupid. It's really dumb. If I'm her lawyer, I'm just tearing into her.
If the jury catches her, she's done. I mean, she's probably done anyway, but if the jury catches her, she's like extra done.
Before we go on the recess break this afternoon, I do believe this merits a small bit of discussion on the topic. The matters that we've discussed at sidebar concerning emotional responses, I do feel it is important at this point. Mrs. Adelson, when the testimony is occurring or the evidence, I know you may have a natural reaction, but as
or an
best
unnatural
possible,
reaction.
you need to control your reactions concerning any head movements, any expressions of disagreement, or any emotional outbursts. The jury must decide this matter on the merits, on the evidence. Do you understand this? Very well. I do not wish to do this in front of the jurors at all, but it's very important that you are able to control your emotions. Do you understand what I'm saying?
Warning.
Does either party need to be heard before we before we go into the lunch break?
No, Your Honor.
No, Your Honor.
All right, please report back at 1:15 as well.
I love this judge. I love how clean and concise and direct that was without going into any accusations directly. But the very implicit warning that is basically saying, I do not want to do this in front of the jury without actually finishing the sentence, because you don't have to. Just give me this judge 10 out of 10. Do approve. Phenomenal. To judge do continuing education. I would do continuing education from this judge all day, every day. They technically speaking, they're required to, as just lawyers, they have continuing education obligations, but it varies by state. Big Dog 5758, the best prosecutor since Brennan, and I am watching closing openings. It is the best prosecutor I've seen since, considering that Brennan was the last one that I saw. No, the one we watched last week was good, pretty decent too. I will give Brennan a whole lot of credit. Lauren, Elev, surprise surgery recovery equals way easier with FNF. Hope you recover well and quickly and rapidly and fully. Chris M96, Rob, building IKEA furniture is fun. Me and my brain. Did Rob ever finish setting up the shop so he can make real furniture? No. I have a humidity problem in the shop. I also have a problem in that there are bicycles and tricycles. Not tricycles, bicycles and scooters in the shop that I need to build a shed for because I can't get to my tools. I'm very frustrated by this fact because I need to do things and I'm annoyed. But
I haven't done any leather work in forever, so I feel you.
Yeah, that is This is to say we're working on some life circumstance changes that we're hoping is going to start getting the house in order where I can start doing stuff on a more regular basis that's healthy for me and everything else, including the shop. Yellow Pill MP, Florida continues to be #1 with trial procedures. I like the trial procedures here. Jessica 8536. Hey everyone. Hey Jessica. Adrian Angebine, for 33 months. Santa might let you have some power tools, but sadly the third and or fourth 3D printer is probably denied. But Santa was the one that gave it to me. Like you can't deny a Santa gift. Fiona W, thank you for gifting memberships. Very kind of you. Lauren Elev, Ian, look into Menti if you like the quiz idea. Menti, MENTI. What was the quiz idea? Let's do this. We're gonna Catlin on Replay Crew. I had to share that my Special Olympic softball team qualified for the state in 2 weeks. Congratulations. They've been on a roll. First time ever we made it to state in softball. I'm so proud to coach. Love you guys. Congratulations. They've been on a real winning streak recently. Minnesota knows in my weight loss journey, I'm down 21 pounds. Congratulations. And I hate you because I'm not. Like we good for you. Keep it up. All right, so we get back in. We get motions arguments. The motions arguments get a little spicy.
Similar sentiments. I don't think they're specifically tied to the visit that's referenced in that particular email.
Are you arguing then that the defendant had a consistent animus towards the deceased?
Oh, yes.
Very well. Over objection, I will permit it only on the grounds that it shows that the defendant had a consistent animus towards deceased or his family. However, if the defense is asking for a limiting instruction as to this evidence, you may request it now.
It was really stupid not to ask limiting instruction, by the way. Big Dog, I misread your super chat out of context. I didn't realize you were referring to the best prosecution since Brennan, and you were actually referring to the defense. That was my bad.
That's fair.
So, it was fair. It was the timing, and that's my fault, not yours.
If we're asking
yes, we would ask for limiting instruction. This is not directed towards Danny Markel. I mean, if you take a look at it, Mrs. Adelson is complaining that Danny and Wendy have to schlep the boys down to see his parents instead of them driving up to see the boys. It has nothing to do with trying to keep the boys from the family. So I'm not sure what limiting instruction would be effective, but this is as to, it doesn't express any animus to Danny. So I'm not sure what the court would suggest.
His family.
The state's theory is not hatred towards the Danny Markel's family. And so I'm
Ms. Kaplan,
confused.
as to the state's theory, please clarify this issue.
State's theory includes that Mrs. Adelson hated all things Dan Markel, and all things Dan Markel needed to be erased from these children's lives, including the grandparents. Now, I know Your Honor has precluded me from mentioning visitation with the grandparents and things like that, but obviously that's always been a part of the state's theory, and I understand that I'm limited from including that, but it is important to show that this animus existed as far back as 3/28 of 11. And this is the first item in the exhibit because it goes back the furthest in time. I think it's
Bro, that judge was ready to rule 4 blinks ago. If you have not picked up that this judge has tells and his blinking is a tell, you need to, Madam Prosecutor, you should have stopped arguing about 2 minutes ago. He was there with you. All the blinks are just like, he's starting to talk. And you just stop getting in your way.
important.
We're not going to be wasting a lot of time on this back and forth. This is the point of pretrial motions. On this point, as it relates to the state's theory of the case, that the defendant had animus towards the deceased or his family. It will be permitted on those grounds. If the defense is asking in some way for a limiting instruction to be given, please request it now.
Yes, Your Honor.
What is the limiting instruction that is requested?
Oh, baby.
Your Honor, I'm at a loss.
Nope. Wrong words.
I-
Wrong.
I think that an instruction that, I mean, this doesn't show hatred towards Danny. So again, I'm not sure. Obviously disagree with the state's argument concerning this.
He's
What
ruled-
else would be considered for the defendant's state of mind as it related to the deceased or his family?
I would ask that it be related to the deceased's family. It's not to do with the deceased.
Ms. Kaplan.
Let me tell you how you handle this judge. You handle this judge by saying, Your Honor, thank you for the grace of letting me ask for a limiting instruction. Will you give me 1 moment to confer with counsel on the specifics of what that instruction should be? The judge will give you that time as long as it looks like you're actually being productive with it, and he won't be frustrated that you're asking for it. You look over to your counsel and you come up with a string of words that you agree that you're going to ask the judge to do. You don't quibble over whether the judge was right or wrong. You get to the point of what the ask is, and the judge will either grant it, deny it, or tailor it down. This should have 100% been, this was a terrible way of handling that. And with this judge, you're screwed if you start walking that path, because he's getting angrier and angrier and angrier, and you can see it happening. He's like boiling.
Oh, he's got all the opinions.
I would be, and if you can't pick up on that and you can't adjust your litigation strategy based on him, oh, you better, something's about to happen real bad.
Well, down.
There's 5 more items, Judge.
Let's go through them.
Yes, sir. State's Exhibit 64D is an email dated 10/26/12. May I approach?
Good night.
This email is from Donna Adelson to Wendy Adelson, showing her a list of prospective love interests from the website. Mrs. Adelson has identified as potential matches for Wendy. It's offered to show how controlling Donna Adelson was over the children's lives, how much she inserted herself into their private lives. And again, she likes to be in control of who they date and who they marry.
I mean, that's not great.
No.
Response.
Judge, this is not an email from my client, Wendy Adelson. This is an email from Match.com to the email address that my client has.
Did she just say not my client, Wendy Adelson? She did. Whoops.
It doesn't say anything, the copy I have at least, doesn't say anything at all about Wendy Adelson.
Okay, I'll replace it with a copy that shows the email heading on the top, Judge.
It's my fault.
And this was her forwarding this or actually including some sort of message?
She forwards it. I'm not sure if she included a message. She definitely did on the next one, which is also subject to defense objection. It's State's Exhibit 64I. I'll approach with that as well. Related.
What's the date on that?
What's the date on that? It's capital.
1/17/13 today on Exhibit 64I.
As to any questioning of Wendy Adelson as the role her mother played in her life, including screening potential romantic interest, that question certainly can be asked, but as to an exception to hearsay, what is being offered concerning this?
God, I love it. It's like he knows the rules of evidence. It's phenomenal.
Yeah.
It's like he actually knows what hearsay is and that there are exceptions and that you have to put the burden on the individual to prove the exception to get it in. Just phenomenal. It's great. It's like he's a judge or something.
The relevance of it or
Yeah.
the exception to hearsay is
Well,
a
it's
statement of
actually
a
both.
party. Relevance is that Mrs. Adelson was very controlling and micromanaging in her children's lives, particularly in their love lives, which directly relates to the motive.
What hearsay exception is that?
Yeah.
That's not a hearsay exception.
He's
That's
saying-
why it's
he's saying
useful
party
to you.
admission.
Mr.
I
Markel.
don't think it is.
You get it, you get the idea.
I just can't understand how this would be material to this case in any way, anything that the state has to prove. It's not, we just want to bash her reputation or what she did. They got to prove criminal offenses against her. How does her being on Match.com while she's living with her daughter have anything to do with something the state has to prove here? Nothing.
I believe this once again goes to the issue
Oh.
of motive. I understand the defense's position that you disagree. As to this motion, or excuse me, as to this item, this is you said 64I.
64D and I, Your Honor.
Right. As to whether the defendant in any way possessed a motive concerning Wendy Adelson, or excuse me, as it related to the deceased in controlling who Wendy Adelson may have sought as a romantic interest. Ms. Kappelman, do you have other evidence that's going to tie that to this particular item?
I do have other evidence that Mrs. Adelson was just on the wire speaking about Wendy's love life and her current love interest and who she wants her to date and discussing with Charlie Adelson, wanting Charlie to intervene with Wendy and encourage her to date a certain person. So I do think it is a theme that we're.
Side note, this is a defense counsel's judge, by the way. If you haven't picked up on the fact that he is putting burdens in front of the prosecution, He just said, you better draw a nexus. Give me a proffer of what your nexus is. He didn't say it in a direct confrontational way, but he was saying, before I'm going to let you get to this, you better give me something. You know how many judges would just bypass that inquiry and go straight to the, yeah, it's relevant. This is
Merges with other evidence.
Well, as the state of mind and motive, I will permit this evidence to be given over objection. However, as to the foundations for these things, Ms. Kappelman, they'll have to be laid through the appropriate witnesses.
look at, you ready to see the attorney say oh shit in their eyebrows? This
The
watch
appropriate
her.
witnesses.
Appropriate witnesses. What? I gotta do foundation? What? You're not letting me just bypass that and go straight to this email?
Okay, all these items came from a search warrant executed on Wendy Adelson's Google account.
Doesn't matter.
The next item, Judge, is just a moment to locate this.
And she misunderstood what the judge ruled. She's basically saying, no, I can get it in because I can authenticate it. The judge ruled you have to lay a foundation to get to this being relevant. Not that you have to lay a foundation like, hey, it's authentic. Hey, yeah, I got it via subpoena. No, you don't just get to jump into it. Elf Wiggins, I'm teasing. And I'm talking more about Judge Bev Canoni. Just Judge Bev. Mostly. But this one is like, you have to lay the factual foundation to get to this evidence.
I believe it's 64W, an email dated June 27th, 13. And the objection in this case relates to the characterization of Judge Hobbs as a, can't find the quote, but something like a Southern black lady. They just were proposing redacting that. Find the page for your honor.
This would piss me off if I'm a judge too. Why are we page by page through this? Why are we not knowing?
That email, I'll give you one and two. Second page, 2/3 of the way down in the second paragraph, mention of Judge Hobbs. There's no particular relevance to that characterization of Judge Hobbs, so I just don't think it's prejudicial, so I don't know why we're redacting. Whatever your honor thinks on that one, Judge.
Folks.
I believe the jury could take that as in a very derogatory way. It has absolutely nothing to do with this case, that comment. Nothing. Unless there's another motive I don't know about.
The family law case is kind of part of the motive there. So I can see this getting in. Family law case is the motive.
If in some way, since we do have two jurors of African American descent that would otherwise impute on the defendant a negative character trait, I will permit the redaction for that reason. Beyond that,
Oh, I can guess what word she used. It's like the math just math for me.
Just the, I don't know that it said that. I don't know. I'm not going to draw that conclusion.
Oh, I'm drawing that conclusion. That's the math that just math for me.
He was like, in an abundance of caution, given the fact that there are two Black or African American jurors, we're going to go ahead and strike out the word that's probably going to make them look at you and not give you a fair trial for the rest of the rest of it.
Yeah.
It said Southern black lawyer or Southern black judge. I don't know if there was more. I don't know if it was anything else. I think let's put it this way. Let's say it said a Southern black judge, but then the words kind of before that and after that would imply something bad about that, which I'm guessing it does. Note to people, watch what you put into emails that become subject to subpoena. Just saying.
7/2015.
Well, I gather. I'm not saying that it was. I'm saying it can come off a little racist. You don't want the jury.
What's referenced here is 64HH. Yes, sir. May I approach?
Okay.
May I have the other exhibit? Judge, this email is an email regarding Wendy moving, and the evidence is going to show that she moved from a more secure location to a less secure location. So the relevance is sort of going to have to be developed as the trial goes on. But the idea is that there was no fear for Wendy's safety.
What's the date?
That email is dated.
7/15, I believe, is the last date in the chain.
Thank you.
If you have to start the foundation with one witness, but enter at a later point.
Now, what was
that's
Jim
certainly
doing at this
appropriate.
time?
What is the objection?
Well, Judge, I have a question. The email that I'm looking at that was provided to us on July the 15th, 2014 is to Jim.
So, Northwest, context, a Southern black lady judge would like the boys converting to Christianity. If that is what the email either says or infers, I know several people who would probably take offense to that suggestion, take offense to the race being inserted in that calculation or in that computation. I can also see people stupidly saying that. I can read that any number of ways. So I can see people taking that being derogatory. I can see people not, but the judge was basically saying on the risk that one of our jurors might take offense to that, we're going to go ahead and redact it.
Which
And it was
is
talking
you
about
know,
the family
reasonable.
law judge, which is the proper remedy to do. Side note, if Southern black lady judge was the meanest thing that was in those emails about a judge, which I'm doubting they were, then it's probably there's very good natured emails, because I've seen a lot written about judges that should not be put in emails.
For cost from Wendy Adelson.
I believe these are from David Trafton at MiamiRealEstate.com.
That's not what we're given.
May I show the exhibit to the defense?
Clear as day.
This won't age as well as you think. This judge is pretty chill, unless you start fucking with time with the jury. He then gets less chill. Appropriately so. He's like, why are we doing this right now? Do we need to do this right now? The jury is waiting.
He's like, we got places to be. Specifically,
now
the
answering
jury's got a
emails.
place to be.
He's like, I am now answering emails because y'all are not on your shit.
That we've been handed is April
He's
7th,
doing his Wordle for the
2015,
day.
4:42
I'll be
p.m.
right.
This is regarding Wendy moving It had the same security as where she was living with her mother, so less secure.
I'm gonna ask Ms. Adelson about that. My understanding is it is less secure. They're asking lots of questions, but they're not about security. But they're being actively extorted under threat for their lives. One would expect and would inquire about such a thing.
You may lay the foundation, or at least begin to lay the foundation for that item with when that witness is examined. Going back to the last trial in this matter, when the intent instruction was given, the intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case. Specifically, as counts 2 and count 1 that are charged in the indictment deal with aspects of intent. I'm going to find evidence that demonstrates the defendant's alleged motive, which goes specifically to intent, is admissible.
That's broad as fuck. That is a
One
broad
thing, though, that is
the definition
starting
is
to trouble me with those. We had many motion hearings in this matter, and we've continued this case several times to handle these matters pre-trial. Why is this coming up now?
The exhibit that we were providing.
Oh baby. I
He
don't
is, substantially less chill at this point.
uh-huh. And I am substantially more guarded at this point. Like this is a gird your loins, like this that's a look you don't like seeing from judges. Not a fun one.
With. I went through thoroughly and had all of my objections listed, and then was told that's not correct. It's another binder. It's different emails.
See, counsel, you're smiling and he's not smiling. This
The
is
binder
not.
I was handed by the state was completely discombobulated, not in date order. It was a train wreck.
As the state's exhibit you're referring to.
That's correct. And so then they provided us with this binder. It appears to maybe still be missing something, but they have a list, an exhibit list, everything laid out by date, by exhibit A, all the sub-exhibit numbers. So that's why, Your Honor.
We're not going to waste the viewers' times. At this point, we're 30 minutes behind where we should have been. Are there any other matters that need to be addressed?
There's one more that I asked for, Judge. It's dated April the 20th of 2016. And it's an email about whether one of the children is sad.
64II, Judge, it's an email specifically in which the defendant is claiming that the child cannot be sad about the death of his father. Extremely relevant.
Whether the child is sad versus whether the child is sad about the death of his dad are very different meanings.
Yeah. One of them not, the other one quite relevant. Yeah.
Its probative value is outweighed by the undue prejudice, Your Honor.
Yep. Oh, if you find yourself making that argument after you started with a good one, you're losing your argument. If you started with a really solid argument and then they said a word and now you're back to, hey, the probative value exceeds, or the prejudice exceeds the probative value, get ready to lose. That's what's happening. Don't make me turn this court around. That's what it does. Had to go back and screenshot that face. Need to practice it since one of my kids just became a teenager. The judge is.
Going to motive or state of mind. is arguing concerning this particular email.
The undue prejudice is what the state is arguing, and they're going to argue to the jury, is that this email says that Donna Adelson said he could not be sad about his father. What she's describing is her time with the child, and she hasn't seen him sad. And it's 2 years after, unfortunately, Mr. Markel was killed.
Ms. Kettleman, if you wish to proffer the testimony from the witness on this, I'll allow you to do so at the presence of the jury, but this one is seeming a bit attenuated.
That Mrs. Adelson.
In commenting on how the child is said.
Sure, Judge, but it relates back to the motive and thinking that it wouldn't harm the children. It was going to be good for the children to get rid of their father. Children have no memory prior to this young age that the father was killed. I think it goes to motive, Judge.
That
I might need some context. That
allow you to set up your foundation within parts if you need to do so.
yeah, that's gonna need a lot of
Whether
context.
this item can be admitted at that point.
Sir, there's one item that I've added today in light of the opening statement regarding Mrs. Adelson's use of the Skype to facilitate visitation with the father, stated December 18th, 2013. It has been previously provided. It's now marked as State's Exhibit AA.1. While the defense is looking that over, I also have a stipulation of the parties may I approach.
You may.
This will be the first thing. I'd like to have your honor read this to the jury as soon as they come back in.
Florida, can we teach you how to make floors in courtrooms that aren't fucking hollow? Like, please, every time. It doesn't need to be a hollow floor. I get it. Technology needs to be installed. Shit, put some sound dampening in those fucking things. All right. So they come back, they bring him on the
Something that
stand.
your office.
He's there. He reads the emails. They're not good. They paint him like an asshole. There's objections. The jury gets sent out. The judge gets pissed.
Claiming has no tie. You're handled.
All right. Witness excused because he objects. He says, there's no foundation. I'm raising this issue again. Judge, you ruled they had to make a foundation. They start making a foundation, and he's like, no, they didn't make the foundation. Send out the jury. And the judge, who's already kind of forecasted to you, he's not having this. It should be done by pretrial motion. And this brings up the question that I had saved a little bit earlier. One of the questions that I said, does the opposing counsel have to organize the exhibits for you? They have to identify their exhibits in a fashion that allows you to know what it is they're actually talking about. They can do that by bait stamp. They can do it by reference to a document with a specific heading or a date. They just have to identify it in such a fashion that you know what the hell they're talking about. It doesn't have to be specifically organized. They just have to say, I intend to use this email chain dated this. That gives you enough advance notice to say, hey, I see what this exhibit is likely to be. I'm going to file a motion in limine so that I can have this argument ahead of time because I need this excluded. Sound right, Ian?
I missed what you said there.
Yeah. They don't have to organize their binder. They have to give you the exhibits identified to a level of specificity that you know what the hell they're talking about.
They can organize it however they want, and sometimes they just have to be able to refer to it.
Yeah.
So, I mean, it can literally just be like, we're now looking at the affidavit of so and so.
Yeah.
Yeah.
So to say that I got this and it's unorganized is not an objection.
One of your jobs as the lawyer is to organize your shit. Now it is courteous to.
At this point, I'm
Yeah.
nearing becoming inclined to send the jurors home for the day, as we are wasting a significant amount of time on matters that were either previously litigated or now are still being challenged for reasons that could have been handled out of court. Mr. Zellman, for any item that is being objected to with State 60.
Anyone that was anyone that was wondering what the facial expression is that you need to control your teenager, it's this. So just if you want to master this, it's this. It is the facial expression that basically says, I will broach no argument. You will shut the fuck up and you will sit down. And unless it is yes, sir, no, sir, or I respectfully don't know right now, sir, but I will get back to you as soon as I can, you shut up.
That you are claiming has no tie to your client's communications. You need to look through that binder now.
Judge, part of the objection that we're making concerning that is without laying the foundation through a witness with personal knowledge, there is no tie to my client. Anything, and specifically anything post-dissolution, so post July 31st of 2013 that's in here, there's no evidence.
I heard this argument previously.
Yes.
It has been ruled upon.
Yes.
At this point, if the state has multiple witnesses that the foundation can be laid through, your objection will be noted for the record, but we are going to move on. If you need to look through this binder to match it up with specific communications in which you believe no foundation can be laid, you'll need to take the time. But as far as wasting the jurors' time on this any further today, what else does a defense need to look through concerning these exhibits?
If the answer wasn't immediately available to you based on the judge's statement, you sit your ass down. He is like, that is the epitome of this. Is you are in fuck around and find out territory. How much further you want to go? This is so awesome. I love this judge. Oh my God, it's phenomenal. Yep.
Before we leave here today, if we need to go through every single state exhibit to deal with any objections concerning them, we will do so, however long that takes. But we're not going to be wasting the jurors' time.
I remember I had a trial where the prosecutor said, I need to be out of here by 4. And the judge said, nope, we're staying here as long as we need to finish up today. And the prosecutor ended up folding. They're like, we're done.
It's this. Teresa says emphasis on every word. Patience wearing very thin. Yes.
Yeah.
It's all of that. It's so scary. I am scared. Poor counsel standing there, just flipping through their binder, just completely just aloof to anything. Like, I'm in danger. Dude, this if he has kids, those kids, you just know those children come home and he's like, give me a report of what happened. They are telling him the God's honest truth. Oh, that's scary as hell. Oh, it's this part where he starts cracking his knuckles. I never want to be looked at the way this judge is looking at these attorneys right now.
That expression is just like,
And it's just, I'm leaving this playing because it is the stone-faced cold expression, like he is about to rip someone's head off. It's also not helping that oh, he's cracking knuckles.
Your Honor, subject to our objection concerning establishing the foundation for proving my client's knowledge, we're ready to proceed.
Concerning that, Ms. Kappelman, between former Detective Eisen, Wendy Adelson, or any other witnesses, are you going to be establishing the foundation as to the defendant's knowledge or connection through multiple witnesses?
May I have a moment, please?
Go ahead.
Yeah, you asked the judge for the moment. He's better with that one.
Mhm.
Oh my God, it
I
is.
have not heard anything about an objection, so I have not planned to ask this, go through every single piece of paper with this witness. I can do that, but that is gonna take some time. I will need a recess to prepare for that. I do have a list of how each piece of paper is related to the defendant, but this witness isn't prepared to go through every single piece of paper in this exhibit.
Are you requesting for me to send the jurors home for the day?
He's an equal opportunity scolder. he literally is like, don't think I'm just taking this out on them. Do you want me to do this to you too? We can do this.
No. I think I've complied with the court's ruling, and I'm requesting that the exhibit be admitted pursuant to that, and we move on.
There does have to be a foundation as to the nexus between the defendant's either communications or actions and these pleadings. That was the ruling. For what was provided in discovery,
that was the ruling is a heavy phrase.
Is that something that needs to be done
Awesome.
in front of the jury judge, or is that something we could tie up later and move on right now?
Right move.
you can tie up later, but it will not be admitted until the foundation is tied up.
Right time.
Okay, Judge, I think that would be my preference then.
Very well. Please bring the jurors up. Please direct Detective Eisen to come back in and take the stand.
Whatever internal monologue he has going on, or whatever self-soothing techniques he has, I need it. I need it. He is so composed, but just, oh my God, this is phenomenal.
Detective Eisen, come back in. That need to be dealt with now while the jurors are out of the room. Please look through it.
This one, and he goes, this
Plus
detective, not a whole lot
All
there.
right, tell us about that.
We get through some of the emails. We don't get to a whole lot of them. We get through some of them. But
Day
the way
one
I
is
want-
usually going to be pretty boring, but
boring.
they end good.
This guy's awesome. This guy is phenomenal. So we go to just, I didn't expect day one to be as good as it was, to be quite candid. We got angry judge, stern face. We got an opening statement by the defense, which was just a nightmare. And then we get
This case, guilty
this guy.
Guilty to what?
to second-degree murder.
If you can speak up, Mr. Rivera, that'd be so.
Must be
Guilty
this
to
up.
second-degree murder.
Thank you.
One moment, Mr. Rivera.
What was your sentence on the second degree murder?
19 years.
Okay, and that was concurrent with your federal sentence, right?
Yes, ma'am.
Okay, and what did you have to do in exchange for getting a 19-year sentence?
Cooperate.
What does cooperation mean to you?
Well, telling.
Telling on who?
My co-defenders, Garcia, Katie.
All right. Did anybody ever tell you what to say?
No, ma'am.
Has anybody ever told you anything other than to tell the truth?
No, excuse me.
Has anybody told you to say anything other than the truth?
No.
Has anybody promised you anything other than the sentence that you got in exchange for cooperation?
No, ma'am.
Did anybody ever tell you, oh, you have to testify about a specific person to get a deal?
No, ma'am. Not at all.
Have you been offered anything on your federal sentence from doing this cooperation on this case?
No.
You catch the smirk on the federal sentence, that's don't give shit.
As part of your negotiation or your lawyer's negotiation of this case, did you give up what's called a proffer, a recorded proffer?
Yes, ma'am.
Right. And even back then, when you gave the proffer, did anybody tell you what you needed to say there?
No, ma'am.
Were you hired to participate in the murder of Dan Markell?
Yes, ma'am.
Who hired you to be involved in the murder?
Well, I got it from my friend, Tudo Garcia.
Is that Sigfredo Garcia?
Yes, ma'am.
How did you know him?
Childhood friends.
So to cooperate and get this deal, you had to turn on one of your best friends.
Yes, ma'am.
Who enlisted Sigfredo Garcia to be a part of this murder?
Katie,
Who's Katie?
his wife.
Is that Catherine Magbanua?
Yes, ma'am.
Do you know who enlisted her to be involved in this murder?
Not really.
Was it a murder for hire?
Yes, ma'am.
Did you know that somebody was paying Katie?
Yes, ma'am.
And Katie was the one that brought the money to you all, right?
Yes, ma'am.
And what was the purpose of this murder as you understood it?
That they wanted the kids.
Who wanted the kids?
Wendy.
Okay. And did you understand that you were killing the father of the kids so that Wendy could have the kids?
Yes, ma'am.
Have you previously referred to a dentist being involved?
Yes, ma'am.
Who was the dentist?
Charlie.
And how was he related?
Katie's boyfriend, side piece, whatever you want to call him.
All right, so Katie was the wife of Garcia, but also the girlfriend of the dentist?
Yeah.
Did you have any contact with the dentist ever?
No.
Did you have any contact with any member of the Adelson family?
No, ma'am.
Everything went through Katie, right?
Yes, ma'am.
What did the dentist, if you know, have to do with the lady in Tallahassee who needed her kids?
I don't know nothing about them. I don't know nothing about that family.
Who was in charge of getting the money after the job was done?
Katie.
How much were you to be paid for your part in this crime?
35.
$35,000?
Yes, ma'am.
Did you know the total amount that the job paid?
No, not really.
Did you know how much Garcia got?
40, I believe.
$40,000?
Yeah.
And did you know how much Katie got?
No, I don't know. I can't remember. But I think it was like 40. I think it was, total would be like 100, something like that.
Okay, somewhere in the neighborhood of $100,000.
Yes, ma'am.
Was it a one-time payment or was it a payment that occurred over time? It's what you got.
No, it's a one-time payment.
What did you know about the man that you came to Tallahassee to kill?
I don't know nothing about him.
How did you know who to kill?
Constituto Garcia.
How did he know?
Katie.
Did you have some information about the man you were here to kill?
Yes, ma'am.
Tell him what that was.
I was a piece of paper with his picture on of his face and address.
Picture of Dan Markell's face?
Yes, ma'am.
And the address of what, where he lived?
Of his house, yes.
Did you and Rivera refer to each other, I'm sorry, you and Garcia refer to each other as brothers?
Yes, ma'am.
Moving evidence states 45, Your Honor.
Okay.
No, Your Honor.
States 45 is amended.
Is that you and Mr. Garcia?
Yes, ma'am.
Please silence your phones.
Good picture.
Mhm.
Have you ever been to Tallahassee before you came for this case, related to this case?
Never in my life.
How many times did you come to Tallahassee related to this case?
This case twice.
So were you with Sigfredo Garcia both times?
Yeah.
Was that one time in June and one time in July?
I believe so.
Okay, and July was the time, second time was when the murder happened, is that right?
Yes, ma'am.
Was it just the two of you on both of these trips?
Yes, ma'am.
Objection states 44. Introduce states 44, Your Honor.
States 44 is amended.
Publishing states 44. Who's this right here?
Garcia.
And this?
Katie.
Who's that?
My baby mama.
Your child's mother?
Yes, ma'am.
What's her name?
Jessica.
Okay, and that's you there?
Yes.
Was this picture taken before or after the murder?
I can't remember.
At the time of the murder, Was Katie with the dentist? Was Katie with Garcia? Was she with both?
Both.
Were you at the time of this murder living with Jessica Rodriguez?
Yes, ma'am.
There's an address on the rental car contract, 1515 Northeast 135th Street, number 14. Do you recognize that address?
That's my apartment. Yes, ma'am.
All right, let's talk about the first trip that occurred in June. How did you get here for that trip?
Well, we rented a car.
Who rented the car for the June trip,
The first one.
if you remember?
Can't really remember. It's so
Okay.
long.
But one of you, either you or Sigfredo?
Yeah, I think it was Fredo. I rented the Prius, so I never rented on the truck.
Okay, so Garcia rented the car for the June trip, but it was a rental car that y'all brought up here.
Yes, ma'am.
Okay, and did you take the same route on both trips to get to Tallahassee?
Shit, I don't remember.
Okay, and did he have the paper with the picture of Dan Markel on both trips?
Yes.
And what did you do on the first trip?
We drove by here and we just followed him around to see where he lived and shit. But
Okay, were you planning to?
Side note, having the paper with the photograph of the target that you are going to assassinate with you in the car is a decision.
I mean, it's helpful if they encounter the guy.
It is. It's also helpful for the police if they encounter these individuals.
Oh, I mean, it's definitely something that they'd want to eat if they got caught.
Mm-hmm.
Kill him on the first trip?
oh, I don't remember.
Okay, did you have a gun on the first trip?
Yeah.
Did you have a gun that you procured specifically to kill Dan Markel with?
Yes, ma'am.
And was that a gun that you bought off the street?
Yes, ma'am.
You bought it.
I bought it.
Okay. And were there any other guns in the vehicle for that first trip, if you know?
I think we had two.
All right. What was the other gun?
It's a 38
Whose gun was that?
Garcia.
On that first trip in June of 2014, did you and Garcia go to Markel's residence?
Yeah.
And did you lay eyes on him that first trip?
I believe I passed by his house and scoped him out.
You said you followed him. Do you remember where you followed him on the first trip?
Yeah, I followed him to a daycare.
Okay. How long were you here that first trip?
Maybe I don't remember.
A couple days sound right?
Just a couple of days.
Why wasn't Dan Markel killed on that first trip, if you know?
If I remember, I wasn't gonna do nothing in front of no kids.
He had the kids with him,
Yes, he did.
but for whatever reason, it didn't happen on that trip.
A lot.
Really nice. I wouldn't do it in front of the kids, but I did intend to kill him. You know, so maybe his kids wouldn't see it, but he wouldn't have, like, the kids wouldn't have their father anymore.
I mean, it is still better than
In front of?
yeah.
This guy is doing a lot of time, and he's doing it for a reason.
Oh yeah.
We lost him. I believe we lost him.
Okay. And when you didn't get it done on that trip, was anyone angry at you?
At me?
Yeah.
I don't think so.
All right. Did you hear at some point that y'all were going to have to come back if you wanted to get the money and finish the job?
Yeah.
All right. So you did come back in July. Is that
We
right?
came back.
And that's when you came in the Prius.
Yes, ma'am.
And you rented the Prius, right?
Yes, ma'am, I did.
Okay.
And why did
And
you
that
choose a Prius?
phone number that you wrote on the Prius rental agreement and wrote brother, that was Garcia's phone number?
Yeah, I think.
You took phones with you to Tallahassee for both trips, right?
Yeah.
Did you turn your phone off for the actual murder?
Yeah, I did.
What about Garcia? Do you know if he turned his phone off?
When the murder happened?
Yes, sir.
Shit. No, I don't remember.
Okay. Did you stay in Tallahassee for a couple nights when you came here the second time?
Yeah, we stayed here for a night or two, I think.
Okay. Did y'all rent a hotel room?
Yes.
Do you know how many guns were with you on that second trip?
No, just one.
You only remember one gun on that trip?
Yeah, I remember one.
And that's the murder weapon?
Yes, ma'am.
The one you bought on the street?
Yes, ma'am.
What type of gun was that?
A 38.
That's a revolver?
Yes, ma'am.
Do you remember an incident where there was a shot fired into the floorboard of the Prius?
Yes.
Could you tell the jurors about that?
When we was driving home, Garcia put the gun out and shot the gas line in the car.
Through the floorboard of the car?
Yes, ma'am.
Passenger side or driver?
So that's, I mean, just clever, you know. Sure. Criminals being criminal and stupid. Playing with a gun in the car. Shooting somehow the fuel line in a fucking Prius. How he somehow found the fuel line in a fucking Prius with a 38. Nice shooting, Tex.
Driver side.
That's
I mean, hey,
Okay. And that was the murder weapon?
It's pretty accurate. Through the
He got
floorboard.
lucky.
That fired that shot?
Well, lucky.
Shit. I don't remember.
Okay. But he was messing around with some gun and fired it into the car.
Yeah.
And were y'all driving in the car when that happened?
Yes, ma'am.
And did it disable the car?
The car started stopping. Little by little, it just started slowing down.
Okay, that's the Prius, right?
Yes, ma'am.
How did y'all get the car going again?
We seen somebody that he knew stopped him and took him to the auto place to get a piece of hose to put it back together.
And the guy that you saw that he knew, are you talking about a local drug dealer here that y'all met on the first trip?
Yes, ma'am.
And that person assisted you in
That was
getting some
leading.
way to fix the car?
Yes, ma'am.
Who was good with cars? You or
Not that
Garcia?
anyone
Garcia.
cares.
All right, so he was able to make a repair to the gas line?
Yes, ma'am.
Did you follow Dan Markel again during the second trip?
Yeah.
Did you follow him to the daycare?
Yes, ma'am.
Did you actually see him drop his children off at school that morning?
Absolutely, yes.
Did you follow him to the gym where he went inside and worked out?
Yes, ma'am.
Was there a reason the murder had to be done on the day that it was done?
I believe so. I believe he was about to leave.
Who was about to leave?
Markel.
About to leave town?
Yeah.
How did you get that information?
I got it from Tudo,
Where did he get the information?
from Katie,
How did she know?
Wendy.
You think Wendy talked to Katie and told her Dan Markel's travel plans?
Yep.
Were you present for that
No.
phone call? Okay. But somehow you learned that Dan Markel was leaving town the day after he was killed.
Yes, ma'am.
So it had to be done that day or he'd be gone.
Yes, ma'am.
Okay. And that came through Garcia to you from Katie.
Yes, ma'am.
And when you say Wendy, did you know who Wendy was at the time that all this happened?
No, ma'am.
Okay, but you did know there was a lady that you were helping get some kids back in
Yes,
Tallahassee.
ma'am.
He just seems like he doesn't
Were you the
care.
driver
So
of the-
why not be honest?
That's what I mean. Like, that's why, like, of all the witnesses that testified today, this dude was the most believable of everything. He was like, I'm in jail for what's arguably the rest of my life. I don't like this deal isn't giving me a deal. So sure.
I mean, he'll probably see daylight again, but he's going to be real old.
He's got federal and state charges, state sentencing that's running concurrent from my knowledge.
Yeah, but it's not consecutive, and
Oh, that's true. Sorry, it's running concurrent, not consecutive. So yeah, he should. Yeah. 25th. We got to get 19 years. You
yep,
got 19. So he
Yep.
served. Okay. Okay.
Green Prius?
Yes, ma'am.
I mean, he's not going to get out
Have you had a
anytime
chance to see the
soon.
gym video?
It is wild that he's got 19 years total, 5 more left. This crime was so long ago. I mean, that's wild that he's been serving.
In the bus video?
Yes, ma'am.
Are you driving the Prius in those videos?
Yes, ma'am.
What happened when you got to the driveway of Dan Markel?
Well, I pulled up right behind him, and Garcia jumped out and shot him
How many times did Garcia shoot Mr.
Twice.
Markel? Did he shoot him? Where was the victim when he was shot?
He was inside his parking garage and sitting down on the driver's side on the phone
And did Garcia shoot him through the window, if you know?
through the window.
How long would you say you were in the driveway?
Just seconds,
How was it decided which one of you would be the shooter?
because I wasn't gonna do it.
You didn't want to be the shooter?
No.
On the bus video, we see somebody in a white shirt kind of jumping around in the passenger seat. Is that Mr. Garcia?
Yes, ma'am.
Do you remember what was happening when he was doing all that jumping around?
I think he was trying to hide a gun. If I'm not mistaken, he was trying to hide it.
What did happen to the gun?
Got thrown away
Thrown away where?
in the ocean somewhere.
All right, who threw it in the ocean somewhere?
He did.
All right, was that on the way back to Miami?
Yes, ma'am.
At some overpass somewhere between here and Miami?
Absolutely.
Where did you go after the murder? Go home?
We got to stop somewhere to eat. Then we went home.
Did you stop at an ATM?
I don't remember.
I'm going to show you States Exhibits 38, 39, 40, 41, 42, and 43. So 38 and 43.
Yes, ma'am.
As far as his demeanor in testifying, he has probably given this testimony either in depositions or in court at least 20 times. Like this.
Yeah, that's fair.
He's probably done this at least 20 times. Because we learned from the defense that he was deposed by the defense. It was probably the case in the prior trials as well. So he has said these words a lot.
Are these images fair and accurate photos of you pulling through an ATM?
Yes, ma'am.
And the date, July 18th, 2014?
Yes, ma'am.
Pembroke Pines, is that on the way home from Tallahassee?
Yeah.
So that's you at the ATM, are you the driver?
Yes, ma'am.
And who's that in the passenger seat?
Garcia.
Move to publish, introduce, states 38 through 43.
Any objection?
No objection.
States 38 through 43 are admitted.
May I publish?
You may.
Is that the vehicle you were driving the day the murder was done, sir?
Yes, ma'am.
Publishing 39. Is that you at the ATM machine?
Yes, ma'am.
States Exhibit 40. Is this Mr. Garcia? Is he your passenger?
Yes, ma'am.
States Exhibit 41. He's the passenger that was jumping around when we saw the car in Tallahassee on the bus video?
Absolutely.
More minutes, folks.
Do you remember when you turned your phone back on after the murder?
Not really.
That's the relevant part of his direct. The cross is quick, very quick. And you get an idea of what the defense counsel strategy is just based on the cross. I mean, it would have been a good strategy if they hadn't gone into the opening statement saying what they did.
Garcia said that wouldn't work, right?
No.
Good afternoon, Mr. Garcia.
Excuse me?
It was your testimony that the first trip you came up on, you scoped out Mr. Markell's house, correct?
What?
Yes, ma'am.
And that
Good
he's
afternoon.
going to be taking his kids to
Excuse me?
school. So when he came out with the kids, you're trying to follow him to the school, correct?
Yes, ma'am.
And you got lost. He lost you.
Yes, ma'am.
And the second time that you came up, you knew he was going to be taking the children to
Oh,
school.
I'm sorry, guys. She says the
Good
wrong
afternoon,
name.
Mr. Garcia.
Excuse me?
I said, good afternoon.
Good afternoon.
I just want to make sure I understood your testimony. It was your testimony that the first trip you came up on, you scoped out Mr. Markell's house, correct?
Yes, ma'am.
And that he was going to be taking his kids to school. So when he came out with the kids, you're trying to follow him to the school, correct?
Yes, ma'am.
And you got lost. He lost you.
Yes, ma'am.
And the second time that you came up, you knew he was going to be taking the children to school. And so you followed him to the school,
At
correct?
daycare, yes.
Yes.
Yes, we know that. He's Rivera. She says Garcia. She says Garcia multiple times.
And then you knew he was going to be going to the gym, right?
I didn't know he was going to the gym. I just followed him.
You followed him to the gym.
Yeah.
Okay. And then you followed him to his house.
Yes, ma'am.
And that's where he was killed.
Yes, ma'am.
And the woman who wanted him to be killed was past you and Sigfredo and Katie. The woman who wanted him to be killed was Wendy Adelson, correct?
Yes, ma'am.
It was she wanting her children, correct?
Absolutely.
I mean, it's helpful.
Mr. Garcia, I'm going to show you what.
Mr. Rivera.
Oh, I'm so sorry. I'm so
Twice.
sorry. I apologize. Mr. Rivera, I'm going to show you what's been
What?
marked as Defendant's Exhibit 50. Could you take a look at that and tell me if you recognize that?
Yep.
And what is that?
Like a profile of everybody's face.
Okay. And did you make some marks on this for me and then sign it on March the 11th of 2025?
Yes, I did.
Just hold on to that for a second. Mr. Vera, when we met with you that day taking your deposition, I presented that to you. You gave us information about what had happened, pretty similar to what you talked about here today, correct?
Yes, ma'am.
And when we were done talking about those things and some information about Sigfredo and Katie, I presented you with what's in front of you as Defendant's Exhibit 50, correct?
Yes, ma'am.
And I asked if you would put the number 1 and circle it next to the person you know as Katie, who you said it was in charge of this whole deal, correct?
Yep.
And did you do that?
Yep.
All right. And then I said, would you put a number 2 next to the person you say did this killing?
Yes.
And you did that, correct?
Yes, I did.
And that was Sigfredo Garcia.
Yes, ma'am.
The first one was Katie McBanois, correct?
Yes, ma'am.
And then I said, would you put a number 3 next to yourself on the paper? And did you do that?
Yes, ma'am.
And you're the one who got the gun that was used to kill Danny Markell, and you drove the car that day. You didn't shoot him, right?
Yes, ma'am.
And then I said, if you would, please put the number 4 next to the man who was killed, and you did that with Danny Markell, correct?
Yes, ma'am.
And then I said, if you would, put the number 5 next to the lady that wanted the man killed. And did you do that?
Yes, I did.
And was that with Wendy Adelson?
Yes, I did.
Then I asked you if the 2 people on the top of the page who have their pictures there, the names Donna Adelson and Harvey Adelson, you see those on the top?
Yes, ma'am.
I asked you, as far as you know, were they involved in any of this? And you said no, correct?
Yes, ma'am.
So I asked you to put X's next to the people who on that page were not involved in this.
Yes, ma'am.
And you did that.
Yes, I did.
Thank you. Just one moment, Your Honor.
Take your time.
I don't have anything further.
Redirect examination.
2 seconds. I mean, it was.
Is Mr.
Yeah.
Rivera released or will he be recalled?
He's to remain under Your Honor.
Very well. Mr. Rivera, please do not discuss your testimony with anyone else available to take it at this time. Parties can approach.
So the entire defense theory is like the thing is the prosecution. If the prosecution hadn't laid out their argument or their theory of the case as clearly as they did in the opening statement, then they might have had something to grab onto with that testimony. Like, you said that Wendy was the one that wanted this, and Wendy was responsible. Wendy was all this, right? But we know that there was a cutout. He didn't know anything beyond what he learned from this other person. If you didn't know that the chain of information was exclusive from one person to the other person, then you would be sitting there going, huh, that seems odd. Of course, that's relevant. But having heard how this information goes and how
well, they still got to prove that all of that, but yeah.
Well, they do, but how deliberate the prosecution was in their opening statement with making it clear in the bump operation how the information flowed. I thought it basically just crushed that.
Oh yeah, I don't think they made too much headway on cross, but it'll depend on what the prosecution gets out. Because all of the stuff on opening, none of that's evidence yet, so they've got to actually get that into evidence. We'll have to see if they manage to land that particular plane.
It's true. I mean, it's going to be a complicated case. I mean, there's a whole lot to go through, and you've seen that the court has put a great deal of effort in pretrial rulings, multiple continuances, trying to get it right as far as what information evidence can be adduced to trial. It should move smoothly. It has moved smoothly. So we're just gonna have to see where it goes from there. Okay, let's get caught up on super chats, and then I'll just play a verdict real quick because the Wolfenbarger, I got to close the loop on that story, and then we'll get out of here. I'm gonna get out of here. Sibling Creature, got my ADHD diagnosis this week and have started medication. Many thanks to you, Ian and Emily, for showing me what I had not previously recognized in myself. Congratulations. Glad that you got the diagnosed and are getting treatment for that diagnosis. It makes a world of difference to at least know what you're going through. And then thank you for gifting memberships. Very kind of you. People that talk to me about ADHD and how they were hesitant in expressing that they had a diagnosis, and then feeling relief and being able to live with that after learning that there are people around them that have and succeed with that diagnosis notwithstanding is always
especially because the main sort of theme you hear from people is like, well, I thought I was just broken and stuff like that. And it's like, no. It's just, work a little differently, but it's not, not broken. And there's people who manage. So
it's definitely it's one of the coolest things that I've had about doing or learned about doing this. Is all the people that have come forward and said all of that. Meme Empress, second trial was going too smooth. The defense anamorphed into a circus act. Anyway, I still want 5 pink fuzzy slap, sexy least apprehension protocol bracelets. Well, those you'll have to order online and do. If anyone's curious about what the hell that actually means, go back and watch last week's live stream. There's a whole section on it. Snoopykins tuning in because sleep is for the weak. Cheers to you waking up. Analytical Barney AB, thank you for gifting memberships. Very kind of you. Kai San, good Saturday morning from Sweden. Happy morning to you. Mel the Frog, Ian, I could knit a fuck cancer hat for the auction. That's very generous of you. Send Ian an email. I think he's taking less or fewer donations this year because of how complicated it can get.
Yeah, and shoot me an email with sort of a proposal first, because it got a little crazy, and I gotta try to manage it because I don't want to have hurt feelings. So
Katie Healing, I'm ambling through the tundra eating berries and listening to this while the dog romps freely. Best Friday ever. It's a good Friday.
That is a good Friday. I'm like, I could use some berries.
Music to my soul. I don't get it. Is the prosecutor accustomed to skipping over laying the proper foundation for evidence before entering it? She seems surprised. Investigators can generally get through a lot of the foundation via what they've learned from other witnesses. And I think that there's an issue with, I think that there is a misunderstanding as to what foundation is being required. The foundation being required is if you are going to try and get information about her anger or frustration at the family law process, you have to get a factual foundation as to why she would have that and why it would be relevant and why it would actually lead someone to have a motive to try and want the person dead. It's not like laying a foundation for getting a photograph or an email or something like that. You have to get to the factual predicate to make this fact relevant or tend to give the jury an understanding of why this would actually go to intent rather than just this person's bad. And she countered appropriately. She said, we'll do this outside the presence of the jury. They're coming back early on Monday. I think they're going to get there at 8:30, go through and lay the foundation outside the presence of the jury so they can get into it first thing Monday morning. Analytical Barney AB, shout out to Sandy for giving to each community. Always. Shout out to Sandy, to the mods, to everybody. It is
100%.
Absolutely amazing how much y'all give. Okay, closing the loop on our last story. This one's going to be a quick one. So we had what?
I'm like,
What?
no, it won't.
It will be. It has to be. It has to be. We had started picking up a case out of Fulton County, a cold case. And the case progressed all throughout the week. There wasn't a whole lot offered in the way of testimony that was super, super, super interesting. I'm not going to go through the closings. I'm not going to go through everything about that. I'm going to go through the verdict because a lot of it was we saw a bit from the beginning of this case and how many holes there appeared to be in the prosecution's case. And this is the case of the Wolfenbarger, Georgia versus Wolfenbarger, the cold case. In Fulton County. And
say that
I might have to turn that volume. It's loud AF. Okay. So it is the daughter. The victim was a daughter of a serial killer. The wife of the serial killer testified to helping the serial killer bury the bodies. This family situation was horrible. There's a lot of evidence that just was not really remembered. They had to use a demonstrative of a reciprocating saw, and I don't know how they got it as demonstrative evidence because the reciprocating saw demonstrative they used was battery powered, but they openly admitted that, hey, the one that we would have had back then would have been a corded one. So it's not really demonstrative. The case was wild. It was ridiculous. I didn't understand getting into it why the prosecution thought that they would be able to prove this beyond a reasonable doubt based on the limited evidence they appeared to have. And based on the fact that the evidence itself was full of holes. Really, really kind of frustrating. Difficult to understand. They did have to bring a witness in. They did have to secure one via sheriff because the witness was uncooperative. That witness got detained the night prior. That witness testified today. The testimony today, the witness was shaking because she was on withdrawals from her.
Oh, that's always lovely.
It was wonderful, right? Credibility wasn't at all a factor for any of these witnesses. The witnesses were all lacked credibility. I've never really seen a prosecution decide to put on. You know what? It was kind of reminiscent of the YSL trial with witnesses that were testifying, where the second it gets up on cross-examination and they start walking through the rap sheet and they start going through the other stuff, you're like, holy shit! How did you bring this trial if you knew this was the evidence?
Sometimes they get hopeful.
Oh no, she did end up being a pretty good witness. She ended up getting a lot of information in there about the daughter's conditions under the direct supervision / control of the mother. Pretty horrible. It was a defense witness that was called. Yeah. It wasn't pretty. But so you get to the end of this trial. Significant resources went to the trial. It was a cold case. They decided they were going to prosecute. They had their defendant. They had their person. And we got something very rare in the case, in any case that we get to see. And we'll go to that now.
Prior difficulties is likely intrinsic, etc. But what I can't find is case law that reconciles this tension between the fact that
Wait, hang on.
if the court has ruled that
I'm moving too fast.
Okay. So let me, so I have sort of a bullet point list of things that I was supposed to do homework on last night. I have, and so let me address a couple of things. Number one, I have looked at the request from the defense to provide a charge on immunity of witness. I think that the better course here is to not give it. It's not directly implicated by the facts of this case, and the defense doesn't need it to make the argument that it wants to make. And so I'm not going to give the immunity charge 13180. Mr. McDermott, you asked me to adjust the circumstantial evidence charge to change the word theory to the word hypothesis. I'm not going to do that. The pattern is the pattern, and I believe the pattern is there because theory is a more accessible plain language word than hypothesis is, and that's why it's been changed. And so we're going to stick with the pattern.
She's like, and no.
I'm not going to give the prior difficulties charge. And that, as I consider it legally, I think there is a conflict in, I cannot find case law, and if you can point me to some, I would appreciate it. But I cannot find case law that distinguishes between the fact that prior difficulties, there's tons of case law that talks about the fact that prior difficulties are likely for intrinsic evidence, right? There's secondary sources and there's cases that say that prior difficulties is likely intrinsic, et cetera. But what I can't find is case law that reconciles this tension between the fact that if the court has ruled, which it has here, this evidence of the dealings between Mr. Wolfenbarger and the victim is intrinsic to the case, then I think that the evidentiary standard is very clear that that evidence can be considered for any purpose. And prior difficulties evidence would be the charge that's been requested by the defense is what would apply to evidence that wasn't otherwise intrinsic, but that was allowed as a prior difficulty. And because I've allowed it as right, wrong, or otherwise, because I've allowed it as intrinsic evidence, it's considered, the jury can consider it for any purpose. And I think that instructing them on prior difficulty would confuse the jury about what the standard is that they are to apply. And so I'm not going to give it. The last issue is really two issues, which is I took under advisement the motion for directed verdict of acquittal on count 2 for felony murder, and obviously the associated jury charge that goes with that. If I grant the DV, then I wouldn't give those charges. I spent a good bit of time with this last night, and while I agree again with the state that there is evidence here from which either facts or reasonable inferences from which a reasonable finder of fact could determine.
Are you seeing where she's going with this?
Mm-hmm.
Uh-huh.
That a homicide occurred and or that Mr. Wolfenbarger may have committed it, I do not believe that there are facts from which a reasonable fact finder could even make a reasonable inference that a weapon was used or what kind of weapon was used. And because of that, I don't believe that I don't believe that there are facts from which the state could present the count 2 felony murder, which requires that showing of aggravated assault. And so I'm going to grant the defense's motion for directed verdict on count 2 of the indictment for felony murder, which means that I would not give those charges. It means that the jury, I need to amend the verdict form to include the sole count of the indictment for murder. We also need a redacted indictment reflecting only that one count of felony murder. What record would anybody like to make regarding that ruling? Mr. Wilson, you're
Just the standard for granting that motion. No reasonable
He's like,
juror.
the record I'd like to make is this sucks, Your Honor.
Yeah. You get one of these entered against you as a prosecutor, and it's pretty much a nightmare. Don't bring charges you can't prove.
standing.
I would, Your Honor, and
Yes, sir.
I'd like you to reconsider it in light of, I did look for some case law, and I thought.
She's like, reconsider it and no.
Would be very helpful to everybody, is case law where a murder occurred where either the body was never found or there was decomposition. They couldn't determine the exact cause of death based on advanced decomposition.
But you haven't put a weapon or a tool or an implement in his hands.
And what I found was Richardson versus State, and the site on that is 278 Georgia 548, and it says that if there is evidence of an act, the jury can, and remember, we're dealing with the standards for directed verdict, whether there's a reasonable path for a reasonable jury to follow the state of facts. And Your Honor, I do think that also on Courier versus State, which is the site is 294.
What is this argument? What is this argument?
He's
This is
rambling pretty bad.
This is
He wasn't expecting to have to fight this, I don't think.
no. No. But her lead up to this was pretty much giving an indication that this is going to be a problem.
A 392. This was a case where there was, I mean, it's very similar to our case in that the remains of the victim were subject to decomposition, and the medical examiner gave an almost identical cause of death, which is undetermined homicidal violence. And that's what we had from Dr. Terry.
Right.
So what, and that was acceptable.
What's the
I
other
believe,
part?
and that's,
Nope. That is never acceptable. What's the other part of that coin? This defendant did it. That's the other part of that coin.
that's actually a felony murder case, Your Honor, predicated on aggravated assault, where there was a non-specific form of aggravated assault. The court said that there had to be some evidence, and I'm going to get there really quick.
Mhm.
Your Honor, and I do believe that the court has evidence, and the jury has evidence. As the court said before, the court was going to consider the prior acts of the defendant to the victim as intrinsic evidence. I think that's critical to the analysis on whether, and this is, like I said, this is directed verdict standard. It is critical when the court makes that ruling that this jury can infer from the fact that he's done it to her in any indeterminate manner before, he'll do it to her, he could do it to her again. I think that's a completely reasonable assumption. And that's what the case law says. They can consider it for any purpose that they choose, Your Honor. So I think that because it's intrinsic evidence that there has been past domestic violence, you've got that. That's the big thing. You've also got the medical examiner saying undetermined homicidal violence. You've also got Rosa James saying, educating the jury on the cycle of violence and what happens. Your Honor, there is a path and I understand where the court was coming from. But I think when you allow intrinsic evidence that can be used for
I think this argument has a smell to it.
It really is terrible. It's really terrible.
Like, I've made some
That's
crap
what-
arguments over my, because sometimes you got nothing else. But the prosecution has the luxury to not do that. Because, like, the defense, you got to argue something for your client. The prosecution can be like, no, we're just going to let this one go. He's not choosing to let it go.
Intrinsic evidence, basically the evidence itself is suggestive of the circumstance which led to it. So like it's either a document speaks for itself, so the document has something in it that describes what occurred or what transpired. It could be, I'm trying to think of how it would be in a physical sense. Like if there's a conviction or something for domestic violence, then part and parcel to that conviction is that there was a battery. Like if there's something is proven because you've proven the other thing. Like, I have proven that this person was a victim of domestic violence, therefore this person was an injured individual. They've been hurt. But to keep on saying intrinsic evidence over and over and over and over and over again, but without actually going back to what it is that you're saying ties this defendant to this criminal act, you're just saying a lot of buzzwords, and the judge has said no.
I mean, doesn't repeating it more often just make it good?
It's a tactic. We learned, Ian, but we did learn that repeating things often in an opening statement for a criminal defense case, if you repeat the state's theory, it's a good opening for a criminal defendant.
I do recall that. That was our conclusion from that.
That was what we learned today.
Directed verdict. It's not whether or not it has to happen, whether it's possible that it could happen. And I think a jury can take that evidence of the prior assault and say, you know what? Given the escalating type of violence, this is now an aggravated assault.
No. Wow. That was the argument?
Apparently.
Oh. No. You don't get to do that.
And this is why she died. And that would bring it in directly with the case law. So that's our argument, Your Honor. I think
Abuser once, dead body. Abuser once, dead body. The jury could possibly infer that abuser once, dead body equals he clearly could have abused again, cause of death. That's a leap. That's a big leap.
the court should reconsider its motion or its ruling.
Oh, this is clarification. So Sarah, and it's my fault for not emphasizing this. This is on a directed verdict standard. So this is not even going to the jury. The judge is taking this charge away from the jury and saying, prosecution, you haven't even given the jury enough evidence that a reasonable juror could look at the evidence that you've offered or you've presented in this courtroom and could possibly reach a conclusion of guilty. So we're not even going to give it to them because they could make a mistake, and we're not going to let them make that mistake.
On the motion and allow this case to go to the jury, because I think there is evidence, and I know the court was struggling with that extra evidence, but it's there.
A couple of questions. One, I was able to pull up the Courier case.
Are you high?
The first case you gave me, I don't know if I've typed it in wrong or wrote it down wrong. Can you give me that slide again?
Sure can. It's 276.
Wait, what's that again?
276.
276.
That's what I think we all wrote down 278, or at least that's what I wrote down. 276, Georgia 548.
Yes, ma'am.
Thank you.
I mean,
I will tell you, I'm one of the reasons that I wanted to make sure I had the right citation for that case is that my brief review of the Courier versus State case is it would be distinguishable because I think in that case there was direct evidence of some sort of scuffle between the alleged perpetrator and the victim prior to the victim then later being found dismembered and in a decomposed state, which is evidence from which a jury could find that aggravated assault, of which there was evidence, caused the death. I mean, I read that case very briefly to be more about proximate causation than about whether there was evidence of an aggravated assault, because it sounds like there was.
Well, and I think when you, like I said, when you is there a path? That's the thing. Is there a path for a reasonable jury to
This is scary.
conclude that the violence escalated and this defendant committed an aggravated assault? I think it's relatively settled that the manner of aggravated assault is not necessarily.
No, he is literally making the pattern of violence argument. That's what he is doing. He is making the pattern of violence argument that there was violence on this occasion, therefore there would need to be necessarily there's violence on another occasion. And because I can infer that there was violence on this other occasion because there was past violence, then the jury should get this and be able to reach the conclusion that this person who is dead because of the escalation of violence that I couldn't prove. That is fucking wild.
Mm-hmm.
Just imagine the implications of that if you were to extend that onward, like that legal principle. Just imagine that. Like they got in a bar fight this one time and they saw each other at a bar a year and a half later. And then the next day the person's dead. The jury should be able to infer that because they got in a bar fight this one time and they saw each other at the same bar a year and a half later.
It's literally just character evidence.
It's pretty wild.
Propensity.
Pretty wild.
Is not really the relevant factor. It's is there evidence? And I think Richardson talks at that, and I think Courier does too. But I think with the intrinsic evidence of past violence and the fact that the jury can consider that for any purpose they want to, and given the standards on a directed verdict, could they do it? Absolutely, Your Honor.
No. He's basically saying the jury could be high, Your Honor.
It's just, Your Honor, the jury could very much make a legal error. They could. And the judge is like, you're right. They could, which is why I'm taking it away from them. Wow. That argument is scary as shit. That's a scary argument. I want to rewind that for a second. I can't believe he said that out loud.
Consider that for, and I think Courier does too. But I think with the intrinsic evidence of past violence and the fact that the jury can consider that for any purpose they want to.
That has to be a misstatement of law. There's no, in no case have I ever seen that the jury can consider past incident of violence for any purpose whatsoever.
And given the standards on a directed verdict, could they do it? Absolutely, Your Honor. That's our position. So I'd ask that you reconsider.
Okay. I appreciate that argument. First paragraph of Richardson says that there were bloodstains found on the victim's bedroom ceiling and walls that were evidence of the infliction of severe blunt force trauma.
That's a bit different. Do you see the difference? Like one is like there's something contemporaneous to the actual injury that occurs. Like what the fuck? That's a little bit different.
That's again factual evidence from which a jury could make a reasonable inference. What we have here is a history, right, between the defendant and the victim, but nothing no direct evidence of a particular interaction between the two of them that could constitute an aggravated assault. And more specifically, there's no evidence from which a jury could infer the presence of an dangerous instrumentality or offensive weapon. And that's really, to me, the deciding reason. I understand the state's theory, but I still don't think that there are facts or reasonable inferences that can be drawn from those facts, from which a jury would be justified in determining that an offensive weapon existed and or that an aggravated assault occurred. There is evidence from which a jury could infer and determine that a homicide occurred. And so that's why I've ruled the way I have. I understand the state's objection. Is there any further record that you would like to make on that point, Mr. Wilson?
I don't believe so, Your Honor.
Okay, thank you.
Your
Anything
Honor, I'd
further?
also point out that Richardson's a malice murder case. It's exactly what you're holding in this case. There's sufficient evidence for malice murder.
Okay. Anything from the defense? Okay. So it is 10:40.
All right.
When she's like,
Yeah.
anything from the defense, it's like, well, you've been dunking on the prosecution, so I don't feel any need to change your mind.
I'm gonna let that play out just the way it is. So that's a thing. And then that was one count. Right? So one count remaining.
President accounted for, Your Honor.
Thank you all. Please be seated. Will the foreperson please stand? Good afternoon, sir. My understanding is that the jury has reached a verdict.
Yes, the jury has reached a verdict.
Okay. And was that verdict unanimous?
Yes.
Okay. And has the verdict been filled in, signed, and dated by you as the foreperson?
Yes.
Okay. Will you please hand it to the deputy? And then you may have a seat, sir.
Sorry about that.
Will the defendant please rise? In the Superior Court of Fulton County, State of Georgia, the State of Georgia versus Christopher Wolfenbarger, case number 24 SC 004201. Count 1, we the jury find the defendant not guilty this 22nd day of August 2025. Will the state and defense counsel please come up and look at the verdict form and confirm that you have no objection to the form or legality of the verdict? Counsel for the state, counsel for the defense, is there any reason that I cannot release the jury?
No, Your Honor. No, Your Honor.
Okay. Members of the jury.
Yeah. It's that is absolutely brutal. Let me pull Ian down real quick till he comes back. That is absolutely brutal. So that's Fulton County. And what is going on in Fulton County? I don't know. But here's the thing. Fulton County, the last week when we started covering that case, we started covering that particular trial, it was the same day, just happened to be the same day that a judge in Fulton County misannounced. I said mispronounced. The judge said guilty when the verdict was not guilty. So prosecution lost that case and not guilty. So let me tell you how rare it is for prosecutions to get not guilty. It's pretty fucking rare. It shouldn't be commonplace for a prosecution to go all the way through to trial and have result in not guilty. If you're getting multiple not guilties on murder charges, something is wrong with your choice and selection of prosecution or in how you're managing your cases. I was just saying this is 2 not guilties in a 2-week period.
Yeah, that's not great.
Yeah. And that's after you lost one of the counts on a directed verdict. What are you doing? It's pretty weird. Wait, what am I hearing out of Fulton County this week?
Oh, that's worrying.
what's happening in Fulton County this coming week? I don't know. I can't do Fulton County anymore. It's wild. It just, I don't understand the prosecutorial. I don't understand how cases work there. I really don't. I don't get it. It just is what it is. So, okay, I'm going to wrap up. I'm going to get the rest of the super chats read. We will be out of here. Let's see.
Yeah, I just gave myself a time limit by taking a muscle relaxant that I know will knock me on my butt. So,
Voodoo Fairy 88, and this is why bad people need defense attorney. They do, because these prosecutions shouldn't be brought. Like, this is it's a mess. If you are trying to stretch a DV that occurred, not contemporaneous, like no direct evidence of an actual crime or an actual incident of conduct, you try to make that stretch, that's pretty significant. Trish 818, in my honest opinion, the DV argument bordered on misconduct. Well, there was also certain things about disclosures that occurred in this trial that was not unshocking given what we've learned about that county in particular. But all right, Adelson trial resumes in earnest next week. And yeah, that's what's going on from what I can gather. I'm not tracking anything else right now. I've got trial next week. Ian has indicated that he's going to do, I'm talking like a lawyer, indicated he's going to do.
I'm going to do,
he's going to try to do intermittent or randomized recaps.
Yep.
Yeah.
So I'll probably do one tomorrow. And then just sort of as I can, because I got sort of junior police to teach, which they're actually a really good class. It's they pay a lot of attention, which is really cool. So yeah.
So there you go. So tune in to Ian's channel for the recap. When he does recap next week, you can damn near bet I will be watching that if I'm not actively in trial. So trial has to kind of take priority. But thank you all for being here. Very much appreciated. 5 hours. So I knew it was going to be longer because we were covering a full opening statements in that case, and that case was complicated as it was. I appreciate you for sticking around. Ian, thank you for joining as always, my friend. Very much appreciated.
Happy to.
Hope you all have a lovely, lovely weekend. I will be using this weekend to organize. That will be my making of something. I will be making the mess that is my house less messy. That is my.
Oh, that's a. I don't know that that's a good choice.
Well, we're going to see until we get sidetracked by a rabbit hole that I will dive down. So we'll see. All right, cheers to all of you.
Been there.
Sorry. Yeah, I know you have. We've both been there. Yeah, fair. Cheers to all of you. Very much appreciated. Thank you for being here. Thank you to the mods for being here. Please hit the like button on your way out. Please, please, please. 2,400 still here. Please hit the like button and leave a comment for any other cases that you want me to take a look at this coming week. Adelson's going to be pretty consuming, but hey, there's things going on here and there everywhere. Have a lovely evening. Have a lovely weekend. Hug the families, hug the friends, and I'll catch you next week. Bye, guys.